My lord, yes, because item number 31, perhaps my lord may not like to take up this matter.
Item 31. Mrs. Ayawala, you are there in that matter?
My lord,
Before any other bench.
obliged.
My lord, item 26, my lord, other side I could not contact. I have to file an affidavit, my lord, in this matter. So, it's very
Mr. Ayawala, just have one of your junior present. Let him remind me when
picking
item
up the phone, my
26.
lord, other side.
Huh?
Other side not picking up phone, my junior right.
No problem. Item 26. Just let him be there.
Yes.
You want to file an additional affidavit.
My lord, yes.
I shall accommodate.
My lord.
All right.
Please, Your Lordship. Lordship, I beg to mention item number 21 as the conducting counsel, Mr. S.P. Roy, is out of station due to some personal
Have you
emergency.
informed? Mrs. Ayawala, you are there in
My
that
lord, I have
matter?
been informed, my lord.
No objection? In item 21, as prayed for by MS
P. Agarwala.
P. Agarwal, learned counsel for the respondent with consent from the other side, list this matter
After 2 weeks.
after 2 weeks on a date to be fixed by the registry.
Blank Lordship.
May I please, Your Lordship? My Lord, sir, I beg to mention item number 24.
And for the
Item
respondent
number
one,
24.
Any objection?
no. And for respondent number 1,
You are
I am appearing on behalf of G. Nath. My Lord, sir.
on behalf of
Mr. G. Nath. My Lord.
D. Nath,
Yes, my Lord. It's
but his name is not there in item 24. You are appearing on behalf of the appellant.
Yes, my Lord, sir.
Your name?
N. Borman.
As prayed for by MS N. Bormon,
Yes, my Lord.
learned counsel for the appellant with consent from the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Yes, my Lord. My Lord, sir, G. Nath, name of Mr. G. Nath will be
firstly,
in
the
the
name should be
post-
appear in the cost.
Let registry reflect the name of Mr.
D. Nath, my Lord.
D. Nath, learned counsel appearing on behalf of the appellant.
Yes, my Lord, sir.
Not surprised.
Lordship, I beg to mention item number 8.
Yes,
Kindly take up the matter after 1 week.
this is a delay. This is an order matter.
Yes.
Wait for your turn. তাত লেখা নাই নেকি order matter mention কৰিব নালাগে বুলি? এটা লেখা, huh? It is written, no? Then why they do not read that? Yes, Mr. Smith.
My lord, I beg to mention item number 11, my lord. It's regarding the seasonal factory, my
In
lord.
fact, I have already drafted the order.
My lord. I need some more time. There's some more judgment, my lord.
I've already typed the order, so I'm disposing it off today.
There are some judgments.
What judgment?
My lord,
Then you should have had it today.
my lord, that's why I seek my lord time.
Otherwise, there is no case. Judgment on what?
My lord, regarding this same matter, my lord, regarding the tea and coffee, which has been
Regarding?
the same subject matter, regarding the explanation of the seasonal factory. There's some judgment from the Madras High Court, where it has also been said that
No, it's all right. That's a Madras High Court judgment.
Well,
I have already dictated the judgment half on the other day as far as the definition of the seasonal factory is concerned.
My lord.
And the remaining part also I have given. That was the understanding. In fact, why the matter was posted today is that in case you come up with the ambit and scope of section 82,
I seek
that
time
I have
till
already
Tuesday, my
got. So item 11 disposed of, you will get the order on Tuesday.
May I
Disposed of
please-
already by 11.
May I please, Your Lordship, item number 16, made for adjournment. Adjournment,
Adjournment
yes,
16.
16.
Adjournment are given merely for asking. It's a part-heard matter. Why do you want adjournment? Can you be more specific and elaborate?
Senior now pregnant,
Sorry?
sir.
Miss
Maternity
Counsel?
leave. Maternity leave.
MS NM Deka.
NM Decca, yes.
Have you informed the other side?
I do.
Yeah, please wait for your turn. Please do not waste the judicial time of this court. Yes, call for the list. S. Datta. Matter is listed as top of the list and the petitioner appellant is not in the court. This is the irony of this court. This, Marshall, please write. Despite the appeal being listed as top of the list, the counsel appearing on behalf of the appellant is absent. List after list after 1 week on a date to be fixed by the registry.
For admission, item 2.
Items 2 and 3 seeks an accommodation, my lord. I am led by Mr. S.K. Singh, learned senior counsel. These two matters can be listed on 16/9, my lord.
As prayed for by Mr. A. Ganguly, learned counsel for the petitioner, list this matter
On
such and such date.
16/9. Same order in 3, my lord.
2 and 3.
Published.
As prayed for by so and so on the ground that the leading counsel has personal difficulty in the matter.
Supplementary list, bail hearing, item 32.
Nobody from the public prosecutor side. This come up for the first? No.
No, yeah.
Get hold of one of the APP, we'll take it up. When Rizwan Akelege ahile mati dibe.
Published.
For orders, item 4.
This matter ready for hearing, my lord. Can be fixed for hearing, my lord.
Lordship, I am appealing for respondent number 3.
What about 1 and 2?
It's complete, my lord. Moreover, my lord, it's a case of announcement, my lord. So insurance is the only necessary party.
There is already an order for listing this matter for hearing. Why has it come up then again for orders?
Not been listed for long, my lord. Perhaps.
All right. It appears that the matter was directed to be listed for hearing in the month of August 2023 by order dated 12/5/2023. Stop. However, the same has been listed today for orders. Stop. Let registry list this matter for hearing in the month of
In August last, my lord, if possible, or September.
in the month of September 2024.
Much
Published.
Basa. Affidavit of service you have
Yes,
filed.
your lordship, my prayer is that your lordship, we may be given some time to take steps to dusty service upon respondent number 2, your lordship.
Your name?
We
My
bought
lord,
her.
I am for the, my lord, respondent number 1. For last 2 years, my lord, this IA is pending. And my lord, I am suffering, my
2
lord.
years.
I am suffering,
No,
my
Lordship,
lord,
This
for
is the
their
23
negligence.
matter.
Yes, 2023 matter. your
Anyway,
lordship.
let them last chance. Yes, your name, M. Saikya,
No, P. bought her.
as assured by MS
P. bought her.
P. Borthakur, learned counsel for the appellant stroke applicant, comma, a last chance is given to take dusty service.
In respect of respondent number 2, your lordship.
To take fresh steps in respect of respondent number 3.
Respondent
through
number
dusty-
2, your lordship.
Respondent number 2 through dusty service.
Lordship, there is another prayer. In respect of respondent number 3, your lordship, dusty service could not be done as address was incomplete. So my prayer is that your lordship, we may be given a chance to take steps through paper publication, your lordship, in respect of respondent number 3.
Further, in view of the submission made by MS so and so that due to want of address service in respect of respondent number 3 through dusty could not be taken, comma, let service be taken through paper publication.
Having wide circulation in
Having
Bihar,
wide
your lordship.
circulation in
In
the
Bihar, your lordship.
The R3 is from Bihar.
Yes, Your Lordship.
In the
Address is from Bihar.
District and state, respondent number 3 belongs to.
Your Lordship, a date of appearance may be given in the last week of October, Your Lordship.
Let them file, my lord, after paper publication and dust.
List after 2 weeks on a date to be fixed by the registrar.
Lordship, some time may be required for paper publication, Your Lordship.
4 weeks.
Obliged, Your Lordship.
Item 6.
None appears for the petitioner when the matter is called. Stop. List after 4 weeks on a date to be fixed by the registry.
Item 7.
I appear for the respondent number 3 in this case. The IA that is for my lord sending back the records to the lower court so that they can collect the money. I had gone through the record, my lord.
They are not there. Are you appearing in item 7?
Yes, Your Lordship.
Item 7.
Yes, Your Lordship.
What is this
Record present.
IA for?
Your Lordship, during the pendency of the appeal, the respondent insurance company have deposited the awarded amount before the tribunal.
Yes.
So without the LCR, the learned member of the tribunal is not in a position to release the awarded amount. So this application is for resending the LCR.
So after, so this order that has to be passed is number 1 to resend the LCR, and after the same is done to
Disburse,
Call back.
so together it has to be passed in this order.
I can be disposed of. my lord.
Heard Mr. D. Mondal,
Yes.
learned counsel for the applicant. Stop. Also heard Mr.
A.
A.
Borkotoki.
Borkotoki, learned counsel for
For
the
respondent number 3.
respondent number
3, my lord.
respondent number 3. Stop. This is an application under section 151 of CPC seeking resending of the LCR, resending of the TCR, trial court records. Avoid saying lower court records. TCR to the Motor Accident Claims Tribunal number 2, Kamrup, within bracket M, Guwahati. Stop. The facts of the present case, the facts of the case is that the applicant claimant as appellant have preferred an appeal before this court, assailing the judgment and award dated 18/4/18 passed by the member MACT number 3, Kamrup M, Guwahati, in MAC case number 2487 of 2012 for enhancement of the impugned award. Stop. By the said judgment, the opposite party, i.e. United India Insurance Company Limited, was directed by the learned tribunal to pay the awarded sum with interest within 3 months. Stop. However, in the meantime, the claimants as appellant have preferred the present appeal, which was admitted for hearing, and upon admission and call for the TCR, the same was received by this honorable court, by this court. Stop. In the meantime, during the pendency of the present appeal, the opposite party, United India Insurance Company Limited, has deposited the awarded amount with interest in terms of the impugned judgment and order before the MAC, before the MACT. Stop. However, since the LCR is not available with the MACT, the learned member was not in a position to release the deposited awarded amount in favor of the applicant's claimant. Stop. Situated thus, the present interlocutory application has been filed for resending the TCR in order to enable the jurisdictional member MACT to release the deposited awarded amount in favor of the claimant stroke appellant. Stop. Heard the parties. It appears that the order sought for is necessary in the ends of justice to enable the MACT to release the deposited awarded amount. Stop. Accordingly, it is directed that the TCR be sent back to the MACT number 2, Kamrup M. Guwahati, and after releasing the deposited awarded payment, the case records be sent back to the registry of this court. Stop. With the aforesaid direction observation, the IA stands disposed.
Much obliged.
Really obliged.
Disposed of. Huh? Disposed of. Unserved notice.
Yes. Served notice.
Await service. List after 4 weeks on a date to be fixed by the registry.
Obliged.
Item 9 and 10.
In item number 9, my lord,
Yes.
I have filed one IA.
To withdraw
civil
the
number 2299.
for withdrawing.
Withdraw 50%.
Yes.
I have no objection. Lord.
This is IA 2299.
Yes.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. Stop. Also heard Mr.
R. Sharma,
R. Sharma, learned counsel for
insurance company.
the sole respondent
Oriental
One.
Insurance.
for the respondent number
1.
1.
for respondent number 1. Stop. This is an application for withdrawal of the 50% of the awarded amount deposited by the appellant Oriental Insurance, not appellant, deposited.
Is
Appellant.
You were
There-
the appellant. Deposited by the appellant stroke Oriental Insurance Company Limited in pursuance of the order dated 23/11/2022 passed in IA Civil number 3298 of 2022 arising out of MAC Appeal number 784 of 2022. Stop. It appears that the insurance company stroke appellant being dissatisfied with the judgment and award dated 4/7/2022 passed in MAC case number 1664 of 2017 awarding a sum of rupees 17,13,727 only with interest in favor of the applicant stroke claimant preferred the accompanying appeal. Stop. Which is that order, that's a 50%
9.
deposit.
Page 9.
Page 9. It appears that in IA Civil stroke 3298 of 2022 filed in the accompanying appeal, this court by order dated 23/11/2022 was pleased to stay the impugned judgment and award dated 4/7/2022 subject to deposit of 50% of the awarded amount by the applicant, by the appellant stroke insurance company before the registry of this court. Stop. It is submitted at the bar that the said 50% of the awarded amount has been deposited by the appellant stroke insurance company before the registry of this court. Stop. Accordingly, the present interlocutory application has been filed for a direction to allow the applicants to withdraw the aforesaid amount deposited by the insurance company before the registry of this court. Stop. Applicant stroke claimant. Accordingly, in the interest, accordingly, for the ends of justice, this court directs that the applicant stroke appellant be allowed to withdraw the 50% of the awarded amount deposited by the insurance company stroke OP number 1 in pursuance of the order dated 23/11/22 passed in IA Civil number 3298 of 2022 arising out of MAC appeal number 784 of 2022. IA stands disposed of.
Applicants stroke claimants.
Yes. Applicant stroke claimant, I have said. This is in page 5 and 6, that last portion, in case you want to see. Disposed of.
Applied.
Yes.
Item number 10, appeal has not yet admitted, Lordship. So that may be, rest may be directed to legis matter for admission. Item number
All right. In item 10, in view of the order passed in item 9, list this appeal for admission
next week.
Any date next week. After date listen it would date on a day after a week on a date to be fixed by the registrar.
Supplementary list for orders at 33.
APP Ahan.
Please, it was already admitted for hearing.
It's wrongly listed.
Wrong manner. Let it be fixed for hearing.
No, there is a direction for listing it for hearing.
Yes. Let it be fixed for hearing.
And it is already admitted.
Yes.
It appears that this appeal has been wrongly listed today in the column within court's orders. Stop. Let the appeal be listed for hearing
Next month, September.
in
Second week.
any date in the month of September 2024.
Highly obliged.
Item 34.
Petitioner in person. None appears for the petitioner when the matter is called. List after 4 weeks on a date to be fixed by the registry. Hearing, na? Call Mr. Iqbal's matter. Did you find that decision?
Yes.
Simpliciter.
Yes.
This is judgment of our High Court, Lordship. Paragraph 28.
Paragraph?
28.
No. You have, this is list of decision. Which decision?
Flag number 14.
Yes. Paragraph?
Paragraph 28.
Yes.
After, in next page, Lordship.
Yes.
After, from 4th line. The Act, this is Assam Urban Area Income Tribunal, as its schemes reflect in providing a self-constrained mechanism for preventing, on the other hand, harassing the tenant and protecting, on the other hand, the interest of landlord. The procedure prescribed the Act is summary in nature, so that the proceeding do not suffer from delay, which in a suit ordinarily suffers from. In order to ensure that the proceeding between a tenant and his landlord remain a simpler one and does not become too protected a litigation, the Act seeks to avoid raising of too complicated and intricate issue of facts and law. So, the Assam Urban Area Rent Control Act, special legislation. So, any dispute between landlord and
That is
tenant.
all right, but I think the query of this court was the scope and ambit of the first appellate court. Is it not, Mr. Iqbal? That was the query of this court, where you said that the spirit of the
Yes.
CPC will follow and not the, and to that you wanted to show some decision.
Yes.
This
And
is on regard of the definition of landlord.
Simpliciter. The principle.
All
of
right,
the Act.
anything else?
And next, Lordship, kindly peruse next judgment, flag number 15.
Hmm.
If your Lordship kindly peruse paragraph 11. Start from middle after 9-10 line, a statutory default. Here it is a category held that if tenant is default and that default is proved, in such a situation, the court even cannot exercise discretion in favor of tenant who failed to fulfill the safeguarding provision.
Marshall. এইটো কিন্তু মই জাজমেন্ট অলপ লং হ'ব কেটে পাৰিম আমি লিখি দিব ঠিক আছে কাৰণ ফাৰ্স্ট টাইম আহিছে এইটোত মই স্পীড ভ্যালিডেশন ইন্ডিকেশন আৰু এই ডিক্টাফোনটো আছে Yes, Mr. Ali.
As per factual metrics, Lordship.
Mr. Ali, it's very difficult when the councils do not understand what is coming from the bench. On the last occasion, if you recollect, I have made it very clear that on merit this court is with you. This court simply wanted to know the scope and ambit of the first appellate court. The decisions that you are showing is on merit.
Third decision, Lordship.
If you do not want a decision in your favor, that is another thing. Because otherwise, this court is on with you as far as the merit is concerned.
The third decision
it is clearly come out from the evidence that has been laid that he is a defaulter. Now, the question, what was urged by Mr. Iqbal is that first appellate court did not frame the points, determine the points for determination. That is why it's a jurisdictional error. This is one of his arguments. Second, according to Mr. Iqbal, all right, the first appellate court has gone into the question of defaulter, but the first appellate court did not go into the issue of bona fide requirement. Therefore, the first appellate court had erred in law. Now, this court feels that there is a substantial compliance. This court feels that just because the determination points have not been laid down, that is not a jurisdictional error. This is what the prima facie opinion of this court, which is in your favor. Now, I am only asking for a handle from you, but instead of giving me that, you are unnecessarily taking me to the merits again.
That 16, flag number 16 will cover that point. Non-framing of point of determination.
Yes, paragraph.
Lordship, paragraph 17 and 21. In paragraph 7, Lordship will find in law spot. Paragraph 17.
Yes. Read para 17.
In the present case in hand, it is seen that under the provision of Section 5 of Assam Urban Area Rent Control Act, a suit or proceeding for eviction of all tenants from the house can be made A, where the tenant is done anything contrary to the provision of Clause M, Clause O, and Clause P, Section 108 of the Transfer of Property Act 1882. B.
Why did you not show this decision at the first instance? This is the decision which is required.
Exactly, Lordship.
Yeah.
And
all right.
Next. In last part, Lordship.
Yes, I have seen. Yes. As the learned first appellate court appears to have dealt with all the important questions involved in the case.
Yes. The-
All right.
As per factual matrix here in
Okay,
this
fine.
case,
Fine. You will be.
citation 2017 4 GLT 76.
If you acquire a this will no? Good idea. Rent control, Assam Urban Rent Control Act খন লাগিব নাই নেকি? On the last occasion, did you hand over that act?
We had ended.
Yes, sir. Yes, sir.
It was there.
It is there.
It was there.
Land revenue manual. This one. Flag mark.
Mr. Iqbal, while I dictate, if there is any factual error, just point out. Item number 11. No, sorry, item number 14. Heard Mr. A. Iqbal, learned counsel for the petitioner. Stop. Also heard Mr. R. Ali, learned counsel for
Respondents.
respondent stroke caveator. Caveat discharge only. Just have a look at it. Stop.
Richard. That was Richard. Richard.
This petition is filed under section 115, read with section 151 of the Code of Civil Procedure 1908 against the judgment and decree dated 7/9/2019 passed by Civil Judge number 2 Kamrup M at Guwahati in title appeal number 112 of 2019 2016, dismissing the appeal of the petitioner defendant and confirming the judgment and decree dated 29/2016 passed by the Learned Court of Munsif number 1 Kamrup M at Guwahati entitled suit number 105 of 2013. Councillors, please take your seat. Well, the facts of the case are as follows. The respondent as plaintiff instituted title suit number 105/2013 against the petitioner stroke defendant before the Learned Court of Munsif number 1 Kamrup M at Guwahati for ejectment of the petitioner from the scheduled premises on the ground of defaulter and bona fide requirement and realization of area rents. It is the specific case of the respondent stroke petitioner stroke plaintiff that the petitioner is a tenant under the respondent in respect of the scheduled premises. And that the petitioner has not paid rents to him since the month of August 2012, and hence the petitioner is defaulter in payment of rent. Stop. It is additionally averred that the suit premises is required bona fide by the respondent for himself and for his family members for their own commercial use. Stop. The petitioner stroke defendant contested the said suit by filing written statement and specifically denied the allegations alleged by the respondent in his plaint and took the specific plea that the tenancy commenced from the days of their predecessor since 1976. Stop. It is further stated in the written statement that after the expiry of tenancy on 31/8/2012, the tenancy was not renewed, but the same continued verbally with an assurance by the respondent that the same would be renewed and the terms and conditions would be given in the form of a written tenancy agreement at a later stage. Stop. It was further pleaded by the petitioner stroke defendant that the agreement dated 1/9/2009 was valid for 3 years and expired on 31/8/2012. However, upon expiry of the said agreement, no new written agreement has been entered into. Correct?
Yes.
Stop. Accordingly, it was pleaded that the petitioner stroke defendant is not a defaulter in respect of payment of rent unto the respondent, as the respondent continued to receive rent till December 2012. Stop. The following issues were framed before the trial court. 1 to 6. Following issues and additional issues. 1 to 7, A to A, page number 4. Thereafter, evidences were led by both the parties, and upon conclusion of hearing, the learned trial court rendered its judgment and decree on 28/9/2016, whereby the suit was allowed on the ground of defaulter and bona fide requirement. Stop. Next part. Aggrieved and dissatisfied by the aforesaid judgment and decree dated 28/9/2016 passed by the learned trial court, the appellant stroke defendant preferred title appeal number 112/2016 before the learned court of civil judge number 2 Kamrup within bracket M at Guwahati. Stop. The next para. The appellate court after hearing the parties dismissed the said appeal by judgment and decree dated 7/9/2019. Stop. Against the aforesaid judgment and decree passed by the appellate court, the present revision petition has been filed. Stop. Mr. A. Iqbal, learned counsel for the appellant, submits that the judgment of the appellate court suffers from jurisdictional error inasmuch as the appellate court has failed to determine the points of issue as required under order 41 rule 13 of the CPC.
Rule 31.
Rule 31 of the CPC. Stop. He further submits that the appellate court has not dealt with all the issues involved in the suit, and merely by determining the issue of defaulter upheld the judgment of the trial court. Stop. That's all?
That's
Mr. A. Ali, learned counsel for the respondent, on the other hand, submits that the judgment of the trial court suffers from no infirmities or material irregularities and therefore cannot be interfered with under section 115 of CPC. Stop. He further submits that the appellate court, having substantially adjudicated the relevant issue in hand, comma, no interference by this court is warranted. Stop. I have given my prudent consideration to the arguments made by the learned counsel appearing for both the parties, and have perused the relevant materials available on record, including the case records. Case records, ahi sir? Including the case records of the trial court as well as the appellate court. Stop. Section 5, right?
Yeah.
Section 5. Apt to refer to section 5 of the APT. Apt to refer to section 5 of the Assam Urban Areas Rent Control Act 1972 within bracket, hereinafter referred to as the Act, for before adverting on the merit of the issues involved in the petition. Quote unquote, a 5 to di dibo, huh? Reading of the aforesaid provision abundantly clarifies that the bar against passing and execution of decree and orders for ejection shall not apply in a suit or proceedings for eviction of tenant from the house, either fulfillment of the grounds mentioned from A to F under subsection 1 of section 5. Stop. In the present case in hand, the specific plea of the landlord, as evident from the evidence deposed before the trial court, that the tenant has not paid the rent lawfully due from him in respect of the house within a fortnight of its falling due, and also for the bona fide requirement of use of the said premises by the landlord and his family members. Stop. Thus, fulfillment of either condition is suffice to exclude the suit from the bar contained under Section 5 of the Act. Reverting back to the facts of the present case, it appears that the trial court has framed that the trial court, by framing issues as whether the whether the defendant is defaulter in payment of rent, has held that the defendant has defaulted, and accordingly held that the plaintiff in para 22 as such plaintiff is defaulter. That should be defendant. That's a typo error.
Yeah.
And held that the plaintiff is entitled to realize rupees 16,800 being area rent for the period of August 2012 to February 2013 from the defendant as paid by him. Stop. The aforesaid a reading of the appellate court's judgment impugned in the present revision petition indicates that the issue of defaulter has been dealt by the appellate court, and after determining the said issue has come to a specific finding that the defendant failed to comply with the mandatory provisions as laid down under Section 5(4) of the said Act and has defaulted in paying rent to the plaintiff, as the deposit in court cannot be considered to be valid deposit in view of absence of evidence to show that there was a valid tender to the landlord and the same was refused. Stop. The aforesaid course adopted by the appellate court does not appear to be erroneous in the opinion of this court. Stop. It is a settled law that this court, while exercising power under Section 115 of CPC, is concerned is concerned with the limited issue of jurisdiction alone. Stop. Mr. A. Iqbal, in order to buttress the point urged as regards non-compliance of the provisions of Rule 31 of Order 41 of CPC relied upon the decision of the Apex Court in the case of H. Siddiqui within bracket death by LRS versus A. Ramalingam, reported in 2011 volume 4 SSC 240. Paragraph 17 and paragraph 18 of the aforesaid judgment is reproduced hereunder for ready reference. A bare reading of the aforesaid decision of the Apex Court amply indicates that if the appellate court substantially deals with the relevant issues involved in the case, there is substantial compliance of the requirements of Rule 31 of Order 41. Stop. Therefore, the aforesaid decision of the Apex Court is of no relevance to the appellant. Stop. As held above, that if any one of the grounds of his ejection as stipulated under section 5 of the Act is available, comma, the bar prescribed under section 5 is not available, is lifted. Stop. In the present case, it is seen that the appellate court has determined the issue of defaulter, which is one of the ground stipulated under section 5 of the said Act, and after discussing and re-evaluating the evidence available on record, has come to a specific finding that the defendant stroke appellant is a defaulter, and thereafter has upheld the decision of the trial court. Stop. As such, this court finds no jurisdictional error in the approach adopted by the appellate court. Hence, the revision petition fails. Sorry, Mr. Iqbal.
Next time.
Dispose. এইখিনি লাগিব নি আপোনাক এইটো দিছ জাজমেন্ট থৈ দিব মৈত্ৰী ইয়াৰ এই লাষ্ট ডিসিশন লাগিব
Lordship, may I pray to frame a time for peaceful vacation of the tenant premises?
hello deeply obliged VC আছে নেকি
Hearing item 12.
APP is here. Mr. Kaushik, do you have the case, scan copy?
Please can you copy the
Yesterday, you also granted bail to a person. Yesterday, item number 10 11. Scan copy there, you also granted bail.
One second. It's item number 3 man.
In DPS case, your lordship, there is 3 accused persons.
This is connected?
Connected. There is 3 accused persons facing
This is
trial.
at NDPS?
NDPS.
Where the procedure was not adopted.
Not adopted.
No, not it seems.
Same.
And 418 days behind them.
But otherwise, trial is.
How many days?
418. Same day they were arrested.
One second. Detained for 400?
400.
400. 400. Not pencil.
418.
Huh?
418 days. 418.
418. and petitioner নামটো চেঞ্জ হৈ যাব মহিদুল ইছলামৰ জেগাত আব্দুল হাই মোল্লা and arrested on
2/7/2023.
same date 2/7/23.
Same footing.
The rest everything will remain same.
Same here.
Instead of N Uddin it will be
S Islam.
S
Islam.
Islam and R Kaushik APP. R Kaushik. R Kaushik. In Namgita, change kore dibo. That's the only change?
Only.
All right, disposed of.
Apply.
For hearing item 12.
No, I do Surya Dev. He about to stick. Disposed of. He file to get him devoted. Yes.
In this case, my lord, I did an objection, my lord. This matter was heard by your lordship, and the dialogue counsel for the petitioner was directed to satisfy the court, my lord, about the maintainability of the petition, my lord.
For the maintainability.
Maintainability, my lord. Because no reply against the tribunal order passed by the London District of my lord, Hailakandi.
This writ petition is for?
We have challenged the order passed by the district judge while deciding the amount of compensation under the Indian Telegraph Act. Now their contention.
What is the objection of maintainability? Mr. Das, what is the objection of maintainability?
Just my lord,
I cannot hear you, Mr. Das. Can you adjust the volume?
Yes, sorry, my lord. I am trying, my lord.
Yes.
Just I am submitting before your lordship by relying on the decision of the Honorable Supreme Court, my lord.
Mr. Das, there is some difficulty in understanding.
Lordship, the judgment
by when can Mr. Das be available in court physically? After?
Another 3 weeks.
So let me post this after 3 weeks. It is very difficult to conduct the hearing like this. I'll have this matter after 3 weeks.
Sorry, my lord. Extremely sorry.
No problem. You take rest. This matter was taken up in video in the online mode due to the medical difficulty of Mr. N. Das, the senior advocate, appearing on behalf of the respondent 1 and 2. Stop. However, due to the disturbance and poor net connectivity, the hearing could not be completed. Give a date after 3 weeks. List on such and such date for further hearing.
Obliged to lord.
Tell me with a week thereafter, you know. Oblige, you know.
Oblige.
Item 13.
Sorry for inconvenience.
No, that's all right. There's no inconvenience.
In the last occasion, your lordship passed an order for submission of written argument.
Prepared?
Yes, sir. Our part already, we have already submitted.
You have given?
Yes, sir. On the earlier occasion, we have given.
Mr. Das Gupta, you have prepared?
Yes.
Have you handed over a copy to the other side? You've got it?
Yes, sir.
Rupak. তেওঁলোকৰ দিয়াৰ হেৰিটো ক'ত আছে চোৱাচোন মই ৰিটেন আৰ্গুমেণ্টছ দিছিলে petitioner ৰিটেন আৰ্গুমেণ্টছ দিছিলে বুলি কৈছে petitioner আছেনে তেওঁলোকৰ দিছে একেলগে দুটা লৈ ল'ব লাগে Mr. A. Das Gupta, learned senior counsel, assisted by MS B. Das, submits a copy of the written arguments in the matter. Stop. The same is kept on record. Record to us in Duta parties. Please check. Let me have a look at the arguments. I'm posting this matter next week, next Thursday date, on Thursday. I may try and dictate the order on that day.
We have to argue this case.
Arguments were over, I believe.
No. My argument was not over.
Is it?
Yes.
Mr. Tiwari, wasn't the arguments over? This is relating to that.
My understanding was that the argument was over, but anyway, what do I say when my esteemed colleague says that his side
Anyway,
is
we'll
not over?
post it.
Yeah, today itself we are also here.
I'm in the midst of this civil bench, so let me complete those matters. Since you have submitted the written arguments, let me have a look at it.
All right, that will be better. Tomorrow they are off, or any day you are also for
next week or
no, but Lord, could I have a specific date?
Yes,
because
yes.
there
No, we are
clashes.
giving. It's 29. Okay.
29th of this month. 29th.
Otherwise, second week September.
29th.
Because first week, this bench will not be available.
Will not,
Either 29th or
sorry.
second week September.
29th. Lord, it could be on 29th. 29th of August.
some factual aspects are to it.
Let me have a look at it. It will
I mean, always
file to deliver.
legal argument.
Duta argument, paisa. Please, Mr. Tiwari, please ask your junior to find out the written argument that was handed over from your side.
It's not there?
It must be there somewhere. It's we're
Sure,
not getting
please.
it.
Well, he'll look into
Yes,
that.
yes.
In case if it is missing, another copy will be
Yes,
supplied. Very well.
It will by slip.
29th of August, so my Lord,
Yes. Yes, Mr. Vaidya, this is that matter.
Quashing
PC
of
Act.
the PC Act matter, my lord.
Yes.
Lordship,
You had given a written argument, I believe, in
yes,
this.
my lord, with
A
regard
summary
to
note.
that,
Yes.
in
Yes.
the written argument which I had submitted on the occasion, I just modified it to the extent that because the judgments had cited about 15 to 18.
Do you want to replace it?
I'll replace it because I put in the relevant paragraphs now, my lord.
Very well.
And I put the compilation of judgments as well.
You
I've
want
added
this
to it.
back?
Yes, lordship, that may be written, my lord. I'll submit this. New one, my lord.
You can give it.
Yes, my lord.
Lordship, the engaged land council is court number 7.
Very well. Let Mr. Vaidya start. This is a parted matter.
Yes, my lord.
Yes.
If lordship has taken up the, my lord, compilation, lordship, I have put the summary of facts here. So I'll just take your
One
lordship.
second. These decisions were relied by you. The
Yes, my lord.
Lalita Kumari, then
Yes, my lord.
Antullah.
To a limited extent, my lord. To a limited extent, my lord.
Yes.
So lordship, if your lordship takes up the summary, the lordship, first of all, the petitioner's role, lordship, that they concern, that which two petitioners are the private persons and which two petitioners were the, my lord, public servants for which the PC Act came into question.
Yes.
They have dealt with, my lord, chronologically as regard to, my lord, already placed that one CR case number 467.
No, petitioners are Gautam Das, Sujit Kumar Das,
Bhaskar
Bhaskar
Das,
so and so, and Mrinal Kantinat. Four.
Four petitioners.
Four, right?
my lord. Yes, my lord.
And 1 and 2 are businessmen.
Yes, my
and
lord.
3 and 4 are government employees.
Are government employees, my
Correct.
lord. Yes, my lord. So, my lord, then taking the matters chronologically, my lord, on 18/5/2018, the first, my lord, CR case was filed, my lord.
Yes.
That is at page number 25. Now, this complaint, my lord, the informant, that is the respondent number 2 before your lordship, he chose not to pursue the matter and the same was dismissed for default. That order is annexed, my lord. That is at page number 31, my lord. On 13/7, that said courts were dismissed. And that the lordship raised a query to my learned friend for the respondent number 2, that as to whether he has averted that the earlier was dismissed for default or whether he has gone for revision. As because, my lord, the complaint case, the quashing of which is pending before your lordship, is ditto same to the complaint petition which was earlier dismissed for default. Now, my
Yes.
lord, there comes the issue, my lord, of whether a second complaint with regard to the identical same facts and circumstances can be entertained, my lord. So
That
for
was
which-
one of the issue.
That was
Because
one of the
according
issues, my
to
lord.
you, that first complaint case was withdrawn.
That was but dismissed for default.
Dismissed
my
for
lord. Dismissed
default.
for default. Now, my lord, with regard to that, the primary Supreme Court judgment, my lord, is arising from the Guwahati High Court only, one Premodar Talukdar's matter.
Which one?
My lord, AIR 1962 876, my lord. My lord will come there because that is a long judgment, and my lord,
It is you have put it in the compilation.
my lord, compilation not the entire judgment, because the second judgment in my compilation, my lord, 2010 2 SCC 631, the relevant part of the judgment is already discussed, my lord. 2010, my lord, 2 SCC 631, that is the first judgment, my lord. First judgment in the compilation, Poonam Chand Jain.
Yes.
Poonam Chand Jain, my lord.
So this is for the on the point of second complaint.
This is on the point of whether maintenance second complaint. My lord, here the issue, my lord.
Paragraphs 15 and 20.
15 and 20, my lord. Here. Paragraph 15 is what was decided is Pramanthana Talukdar's matter, my lord.
That is
the
arising from
1962
Guwahati.
matter, my lord. Yes, my lord. That arose from Guwahati.
All right. Read para 15.
15. Almost similar questions came up for consideration before this court in Pramanthanath Talukdar versus Sarosh Ranjan Sarkar. The majority judgment in Pramanthanath was delivered by Kapurji. His lordship held that an order of dismissal under 203 of Criminal Procedure Code in short of court is, however, no bar to the entertainment of a second complaint on the same facts, but it can be entertained only in exceptional circumstances. The court explained the exceptional circumstances as A, B, C, and D. A, where the previous order was passed on incomplete record. That does not appear to be the case, my lord, in this case. On a misunderstanding on the nature of complaint. C, the order which was passed was manifestly absurd, unjust, or foolish. D, where new facts which could not, with reasonable diligence, have been brought on record in the previous proceedings. So these, my lord, after Pramanthanath Talukdar in 1962, these guidelines were laid down. And my lord, as per my understanding, my lord, till date, these grounds hold good, my lord. So it is for the discretion of this honorable court to see whether the second complaint is maintainable or not. As such, my lord, there is no statutory bar otherwise, my lord, to be fair. Like 156.3, my lord, 154.1 and
the exceptions has to be there.
Exception has to be there, my lord.
First is where the previous order was passed on incomplete record, or on a misunderstanding of the nature of the complaint, or the order which was passed was manifestly absurd, unjust, or foolish, or where new facts which could not with reasonable diligence have been brought on the record in the previous proceedings. But this is in relation to a dismissal order. This is not for default, isn't it?
Yes, my lord. Dismissed
Here
for
it is for
default.
default.
Here it was dismissed for
It's for
default. my lord.
default. So how is this applicable then? Because here none of these things have been gone into. There is no application of mind.
Yes, my lord. Yes, my lord. So that part remains, my lord. So, my lord, second complaint, the complaint being a second complaint is not my primarily ground of hitting
Yes,
it, my lord.
I don't think.
But my lord, lordship lays this query, my lord. That's why
Very
I
well.
raised the point
Very
of
well.
law, my lord.
Appreciated.
My lord, 22 SCC online 1705 follows the same line, my lord.
Which
my lord,
one?
Premanthana Talukdar, that is the next one, my lord.
2022.
Yes, my lord.
That is also on the same line.
1705. This is on the same issue, my lord, as regard to maintainability of the second complaint.
That is also on merit.
On merit, my lord, and my lord would find the findings to be of same nature, my lord.
Which paragraph?
In my lord, paragraph 14 and 15, my lord.
This is Justice Suryakant's order. Yes.
Yes, my lord.
14 and 15.
14 and 15, my lord.
Yes, they refer to the 62.
My lord, yes, 62, as well as the earlier judgment which we have referred to, my lord.
In both these cases, including the 62 case, it is on merit, right? The dismissal.
Yes, my lord. Dismissal is after going through, my lord. Yes, for default. So default, my lord, in fact, I've seen also in certain matters, my lord, has rather been, my lord, considered that it can be considered. Only thing, my lord, is that no revision or reinstating, or my lord, at least an avertment that earlier case could not have been pursued because of COVID or whatever reasons, my lord.
All right.
Now, my lord, coming back to the first page of the, my lord, written arguments.
Yes, 1 second. In this revision petition, you are challenging the
My lord, this is a 482, my lord, criminal petition.
criminal petition. You are challenging
My lord, the
the
order
registration
on
of
the basis,
the FIR.
Yes, my lord. Registration of the FIR was done on the basis of the magistrate's order. So I'm challenging the genesis, my lord. That is the order, my lord. Impugned order dated 21/1/2019. Because on the basis of that order only this FIR was registered.
So both
Impugned order and
JMFC's order as well as the registration.
consequent registration of the FIR, my lord. Because that was a consequential registration, my lord.
Yes, please.
Yes, my lord. So coming back to the, my lord, this summary, my lord. Then on 13/7/2018, this first complaint was dismissed. Then, my lord, 17/9/2018, this present impugned complaint was registered, my lord. That is at page number 19. My lord, 2 points that is to be looked into, my lord. That is no avertment about the earlier complaint petition, whatever lordship makes of it. And second one, my lord, this is a mandatory provision, my lord. No avertment in the entire complaint petition or the supporting affidavit at page number 24, my lord, that R2 has made an FIR under 154(1) of CRPC to
This
police
is
station.
all relating to the first complaint.
No, my lord. Second, first one is gone, my lord.
No averment about the first case.
About the first complaint in the second
Yes.
one, my lord. Yes, that is not my primary contention. But the second point, my lord, second arrowhead, my lord, that is my primary contention in this quashing application, my lord. That in neither in the complaint petition's body nor in the supporting affidavit at page number 24, there is absolutely no mention that 154(1) and 154(3) have been resorted to. And rather, my lord, my learned friend has
154(1)
and 154(3). There is FIR before the concerned police station and application or communication to the superintendent of police or the commissioner, as the case may be, my lord.
Not resorted.
Not resorted to, my lord.
Yes.
This, my lord, is now a mandate of law as per, my lord, the direction of the Apex Court in Priyanka Srivastav, and lordship had expressed anxiety on the earlier occasion that could this be considered merely to be irregularity or can it be rectified or cured? So, my lord, going into the judgments, my lord, I've placed the Apex Court judgment 1 following Priyanka Srivastav, and my lord, our High Court judgment, which deals with, my lord, identical same issues, my lord, by Honorable Justice C.R. Sharma. We'll get to there, my lord. And, my lord, another case of the Bombay High Court amongst the 6 or 7 which I have placed before your lordship, where, my lord, the facts are identical, where the Honorable Bombay High Court also, my lord, pondered as to whether it could be irregularity, but ultimately came to the conclusion, no, it is the mandate of law, 54(1) and 54(3). If there are no avertments as such, then, my lord, that is not a curable defect or nor mere irregularity, my lord.
Yes.
Then, my lord, 154, 154(3). Then, my lord, the 21/1/2019, coming to the impugned order at the first page of my written arguments. My lord, the learned JMFC Hojai, after perusal of the complaint and affidavit while exercising power under 156(3) CRPC, directed the complaint to be registered as an FIR by the OC of Lanka Police. This is second head, my lord. With regard to the complaint petition's defect, that is 154(1) and 154(3) not being there. And with regard to, my lord, the court which has done it, my lord, the learned magistrate court JMFC was not the appropriate forum who could have passed this order. Let us assume that, my lord, the complaint was devoid of any defect. Let us assume that 154(1), he has averted that I have filed an FIR before the Lanka Police. They did not register, and that is why I am filing this complaint. Assuming that that defect was not there, still then, my lord, the JMFC Hojai
It should have been the special judge Assam.
Yes, my lord. We could have just returned back the complaint and asked the complainant to file it before the appropriate forum.
Yes.
So this being the, my lord, with regard to the forum, my lord, the points have been put at the bullet head, my lord, and section 5 of the PC Act, specially establishing the special judge Assam's court, which has the dual function of a magistrate court as well as the sessions court while adjudicating a matter. And, my lord, at page number 2, that is the second arrowhead, that is, my lord, has been derived from the judgments which we have placed, my lord, including the Anil Kumar judgment. We'll go back there again, my lord. that only a magistrate who is empowered under section 190 of CRPC to take cognizance, only that court alone can exercise the power under 156(3) while referring a complaint for registration as an FIR.
Sorry, can you elaborate on this?
Yes, my lord. So, my lord, cognizance as defined under the CRPC, my lord, has been elaborated. Now, my lord, 156(3), my lord, it has been discussed and reached that this probably is not cognizance, and lordship was also stressing on this, that this is a pre-cognizance, is merely registration of an FIR. So, with regard to this, so whether if it is only merely a registration of FIR, whether the JMFC Hojai could have done it, and finally after charge sheet the matter could have maybe come before the appropriate court or transferred. So with regard to this, the position of law, my lord, I'll read this statement right out of paragraph 16 in Anil Kumar's judgment. This I've taken from there. So this conclusion, my lord, this has been reverse engineered, my lord. That 156(3), who could direct the registration of FIR? 156(3) is limited. That aggrieved person, the police is not paying heed to his complaints. So, my lord, he knocks the doors of the court. And the court directs that you register this FIR and carry out an investigation and bring the matter to a logical
Directly
conclusion.
156(3) was
Resorted to, my lord. Yes, my lord. Here.
Without first
154(1) and 154(3). So that goes as per Priyanka Srivastava's judgment. This goes, my lord. But however, if it was devoid of the defects which Priyanka Srivastava enumerates, assuming that 154(1) and 154(3) are not taken to be mandatory, or maybe
this
he
is
had
the
complied.
alternative.
This is the second limb of my argument, my lord. Then, my lord, JMFC Hojai could not have done it, my lord.
It should have been done by the
It should have been done by the special judge Assam, who is the concerned magistrate. So here, my lord, under 156(3), if the JMFC Hojai,
so section 5 provides that a special judge under the PC Act shall have the powers and functions of both magistrate and session courts.
this is specifically provided for that reason only, my lord. So, my lord, while looking into it, that whether under 156(3), whether a magistrate, any metropolitan, any magistrate can direct a registration on FIR or not, the apex court had looked into an opine that whoever can take cognizance. Now, cognizance would be, my lord, if it is a private complaint 200, then, my lord, that summoning of accused, that is the cognizance stage. And similarly, when a charge sheet is laid, my lord, after an investigation by police, then after looking into the charge sheet, the cognizance is taken by the court. Now, my lord, after this investigation, if a charge sheet is filed by the Lanka police station, that this has been found anomalies, then, my lord, whether the JMFC Hojai could have taken cognizance, my lord? No, my lord, that charge sheet only cognizance could have been taken by the special judge Assam. So on that issue, my lord, if the court is not empowered to take cognizance under 190, then that very court, my lord, cannot direct the registration of FIR under 156(3). So this resorts to who can, and on the basis of taking of cognizance, the apex court has laid down this principle. So here also two judgments are there. And, my lord, finally what has come, lordship had also raised the query that as to the merits of the case, as to what is the status. So at the outset only, my lord, even though it is not binding, I placed earlier, my lord, these petitioners were granted anticipatory bail in a PC Act matter also, owing to the fact that, my lord, if your lordship looks at page number 39 and 40, my lord, this is a report by the block development officer. He is not an accused person. My lord, 39 of my petition, my lord. Of the petition, my lord.
39,
my lord. My lord, this is on marriage, though this is not primarily, my lord, kind of argued because of the non-maintainability of the FIR. My lord, this is the status which was at that point of time only, my lord, at the completion of the work. And these works, my lord, either they have been completed or they have been, my lord, stopped at halfway level only for the non-availability of funds, my lord. Whatever funds have been provided, those have been exhausted. Now, this block development officer who has given this certificate, my lord, these are completion or closing. Either the works have been completed or the works have been closed by the authorities, my lord. And those authorities, my lord, they are not accused persons, my lord. So, my lord, whatever funds have been provided, those funds have been utilized. This goes to shows from the this report. And, my lord, after lordship's query on the previous date, I have, my lord, raised the query to the petitioners as well. My lord, there is no further development after this. These reports have been closed, and my lord, there are no complaint as regard to their, my lord, non-completion, my lord. And these reports, I believe, my lord, the learned PP possibly will be able to submit, my lord, possibly as a part of the case diary as well, because there was no stay, my lord, in my matter. Investigation was going on, my lord.
Yes.
So that being there, and my lord, the final point being, because two of the petitioners, that is the accused persons in the complaint petition, are public servants, and the offences alleged are under the PC Act. So whether at the point of registration of FIR itself sanction will be required, prosecution sanction. That, my lord, in the light of two judgments, my lord, Anil Kumar's judgment and our High Court judgment of 2015, that is there, my lord, it is mandatory, my lord. My lord, squarely, my lord, 2015, our High Court judgment has said that direction of registration of FIR and both that order have been quashed. There, my lord, there was no forum issue because it was done by the special judge Assam.
For sanction, you are relying on which judgments? One is Antulle.
My lord.
Antulle.
No, Antulle, my lord, will not go into the, because Antulle issue lordship had already
For
covered.
sanction, you are relying on Subramanian Swamy.
Subramanian Swamy, my lord, no, subsequently, my lord, because that I have given in this today's this thing judgment. My lord, section 19, I am relying on Anil Kumar judgment, that is 2013 10 SC.
One second. Go slow, Mr.
My lord,
Bhatia.
my lord.
Why are you in such a hurry?
My lord, page number 3 of the summary.
Yes, the
My
last
lord,
part.
Last part, my lord, previous
prosecution
sanction, 2013 10 SCC 705.
All right.
Well, this judgment
This MWN is from Maharashtra.
This is from Madras, my lord. This is the Madras High Court. And my lord, 2015 4 GLR.
In the 2013 10 SCC, which is the relevant para?
Yes, my lord, we are coming there, my lord. Well, if your lordship permits, may I take your lordship through the judgments now, my lord?
Yes.
Because my issues have been covered earlier as well, my lord.
Yes.
I've just read through the summary, my lord.
But before we go to the, you see, just to refresh my memory, just take me to the cognizance order ones.
Yes, my lord.
And to the registration, the FIR
Yes, my lord.
contents.
Page number 16, my lord.
Page 16.
That is the order. And simultaneously, lordship may take page number 19 as well, my lord. Both the pages.
Yes, let's see 16 first.
Yes, my lord. CR case number 1050. That is, my lord, a complaint petition is placed. It is numbered by the magistrate court office. Then it is placed before the magistrate. 21/1/2019. The complainant is present, heard the complainant, perused the complaint petition and the affidavit submitted by the complainant. On such perusal, keeping in view the nature of the offence alleged and the circumstances of this case, this court deems it fit to direct an investigation under section 156(3) CRPC. OC of the Lanka PS is directed to investigate the matter by registering a case.
Where is the complaint?
That is at page number 19, my lord.
Yes.
So page number 19 to 23 is the complaint, 24 is the affidavit.
Yes, read the complaint.
This complaint, name of the complainant, Ajit Kumar Nath. Name of the accused.
All right, that is all right.
Person, yes,
offenses under 420, 468, 409.
Yes, my lord. Heading number 3.
And 13(1) C and D of PC.
PC
yes.
my lord.
Come to the
Then
relevant portion of the complaint.
My lord, paragraph number 2 is the allegation, my lord. That is the details of the works which were purportedly not completed by the petitioners, my lord. At paragraph number 2. What were the works under MNREGA projects, my lord? Paragraph number 2 and paragraph number 3, my lord. So with regard to these works. Paragraph number 4 and 5 deals with the amounts involved, my lord. So the entire
So
petition
these
comprises
monies
of-
which were sanctioned for these particular schemes and for the improvement of the works was misappropriated. That is the
that
sum and
is the
substance of the
allegation.
allegation.
That is the substance of the allegation. Now the complaint petition comprises of 10 paragraphs. In none of the 10 paragraphs there is any avertment that he had tried to lodge an FIR regarding these grievances. Of course, my lord, as
That's
a
all
concerned
right.
citizen,
You have
that is there.
you've already made that
Yes.
argument.
And
I've
so that
taken note of
basically
it.
is the up to page 24. That is the
Very
complaint
well.
petition.
Then
Page 25 onwards is the earlier complaint, my lord, which was dismissed for default.
all right.
Which is
Now,
identically stated.
pursuant to this, and then at the order
Pursuant
at
to
page
this, my lord,
16, the registration was done.
Yes, my lord. Following order at page number 16,
Where
page
is the
number 17
registration?
and 18 comes, my lord. This page number 17.
That's the registration.
That's my lord, this is this complaint petition. This is how the my lord the investigating agencies operate. Complaint petition, they fix it, give it a FIR number, my lord, under their PS.
So that
this
number
was-
is where? Where is it?
My lord, top of the page, my lord, District Hojai, PS Lanka, year 2000. It is wrong, my lord. 105 of 2019. At page number 17, my lord. District
FIR number 105 of 2019.
2019. So this is pursuant to the magistrate's order.
All right. Now, as far as the allegations are concerned, if this court takes it on the face of it, it appears that a case is made out.
Yes, my lord.
Without going into the other aspects.
Yes, my lord.
On the face of the allegation, a case is made out.
Yes, my lord.
Correct.
Yes, my lord.
And you are seeking quashing of the order of cognizance as well as the registration.
Or not cognizance, my lord, order of directing registration of
Inquiry.
FIR. Yes,
Correct,
my lord.
correct. So parameters of Bhajan Lal will come.
Parameters of Bhajan Lal, my lord, not primarily because I'm on the mandate of law, but yes, my lord, parameters of Bhajan Lal would also come. That is, Bhajan Lal's one parameter is that if it is expressly barred or if it's against the mandate of law.
So that bar you are trying to impress upon the court that the requirements of 154.1 and 154.3 was not resorted, for which the registration is bad.
Registration is bad. That is,
because there
and
is a bar.
154.1 and 154.3 are not mere irregularities, my lord, but
All
are
right, now
mandatory
you take me
requirements.
to the decisions then.
Yes, my lord. And second, my lord, if at all, my lord, lordship takes either 154.1 or 153 not to be mandatory, or suppose some material he can show now also, if he would have filed a reply showing that no, I have not mentioned here, but see, this is the FIR taken to the police station, they have not taken action. Then maybe he has complied with. So that also probably, my lord, was admitted during the arguments that that was not done actually. Then, my lord, the impugn order that was passed by a court which did not have the power to exercise its jurisdiction, my lord. So it is twofold, my lord. The non-compliance of mandate of law is in two
But
folds, my
these
lord.
aspects can be gone into at this stage.
Yes, my lord. My lord, there are judgments, my lord. Exact facts and circumstances, my lord. There are precedents, my lord.
All right, I'll resume in 5 minutes.
Yes, my lord. Lordship. Your lordship, be pleased to take up the compilation, my lord. My lord, the compilation of judgments.
Yes,
my
I
lord.
have it.
My lord, the first one we've already addressed. That is not the primary issue of the petitioners, my lord. That is the complaint was the second complaint, my lord. Because merits were not gone into, and under exceptional circumstances, my lord, second complaint, there is no statutory bar as such. So not going there.
Second
one,
is
my
also
lord.
on the same?
Second is also on the same issue, my lord. This has been discussed. Third, my lord, 2015, 6 SCC 287, my lord.
Yes.
This is the, my lord, the main crux, my lord. This is Priyanka Srivastava's judgment.
1 second. Yes.
So here, my lord, paragraph 31, my lord. Priyanka Srivastava's judgment.
This is on the point of
My lord.
154.
154.1 and 154.3 being mandatory in nature, my lord.
154.1
and 154.3 being mandatory in nature.
3 mandatory.
Mandatory in nature. So paragraph 31 is the conclusion. So subsequent to Priyanka Srivastava's, my lord.
No, please take me to the relevant paragraph.
Yes, my lord. Then lordship may come directly to paragraph 31, my lord.
Here, it has come at the quashing stage.
Yes, my lord.
Quashment of FIR.
Yes, my lord. FIR on the basis of a private complaint.
Ultimately, what was done?
My lord, ultimately this was quashed, my lord. This was quashed on this point and additional points, my lord, as to whether on merit certificate was found or not. But this was held to be the primary, my lord.
Yes, please take me to the relevant
paragraph 31, my lord. Penultimate page. Paragraph 31, my lord. Internal page number 306.
Paragraph
31.
Yes.
We have already indicated that there has to be prior applications under section 154(1) and 154(3) while filing a petition under section 156(3). Both the aspects should be clearly spelled out in the application, that is complaint petition, and necessary documents to that effect shall be filed. The warrant for giving a direction that an application under section 156(3) be supported by an affidavit is so that the person making the application should be conscious and also endeavor to see that no false affidavit is made. It is because once an affidavit is found to be false, he will be liable for prosecution in accordance with law. This will deter him to casually invoke the authority of the magistrate under section 156(3). That apart, we have already stated that the veracity of the same can also be verified by the learned magistrate regard being had to the nature of allegations of the case. We are compelled to say so that a number of cases pertaining to fiscal sphere, matrimonial dispute, family dispute, commercial offense, medical negligence, etc., corruption cases as in the present one, and cases where there is abnormal delay laches in initiating criminal prosecution as illustrated in Lalita Kumari are being filed. That apart, the learned magistrate would also be aware.
I have read. Where is the exact discussion on these 2 points, 154(1) and 3 being mandatory?
My lord, for that, my lord, we have to go through from, my lord, paragraph 25 onwards, my lord.
Let's have a look at it.
Necessity, my lord.
In paragraph 20, I think it starts from paragraph 21, correct?
My lord?
Correct?
Paragraph?
21.
Yes, my lord.
Starts from 21.
Yes, my lord.
Where they deals with the nature of power exercised by the magistrate under section 156(3). Then they go by
the previous judgments.
Anil Kumar is produced. Yes, 25. All right, read 25.
Yes, my lord. Recently, in Ramdev Food Products Private Limited versus State of Gujarat, while dealing with the exercise of power under 150 CRPC by the learned magistrate, a 3-judge bench had held the direction under 156(3) is to be issued only after application of mind by the magistrate, where the magistrate does not take cognizance and does not find it necessary to postpone instance of process and finds a case made out to proceed forthwith, direction under the said provision are issued. In other words, where on account of credibility of information available or weighing the interest of justice, it is considered appropriate to straightaway direct investigation, such a direction is issued. Then, my lord, coming to paragraph 26, Lalita Kumari, here, my lord, the internal paragraph 49. My lord, is a page number 303. My lord, main paragraph 26, internal paragraph 49 of Lalita Kumari's. Consequently, the condition that is sine qua non for recording an FIR under section 154 of the code is that there must be information and that information must disclose a cognizable offense. If any information disclosing a cognizable offense is laid before an officer in charge of the police station satisfying the requirement of section 154(1), the said police officer has no other option except to enter the substance thereof in prescribed form. That is to say, to 154 duty bound to register the case on the basis of information disclosing the cognizable offence. Thus, in plain words of 154.1 of the code have to be given their literal meaning. Then 72. It is thus unequivocally clear that registration of FIR is mandatory, and also that it is to be recorded in the FIR book by giving a unique number to such FIR, unique annual number to such FIR, to enable strict tracking of each and every registered FIR by superior police officers as well as by the competent court to which the copies of FIR are to be sent. Then, my lord, 157 and 154 are again discussed here. Then, my lord, as regards to paragraph 115, as to why the preliminary inquiry is to be done prior to registration of an FIR, which was discussed in Lalita Kumari 120.6. These two have been discussed. Then, my lord, entire Lalita Kumari is discussed. Then we come to, my lord, paragraph 27 here at page number 305.
Yes.
Regard being had to the aforesaid enunciation of law, it needs to be reiterated that learned magistrate has to remain vigilant with regard to the allegations made and the nature of allegations, and not to issue directions without proper application of mind. He has also to bear in mind sending the matter would be conducive to justice, and that he may pass the requisite order. The present is a case where the accused persons are serving high positions in a bank. We are absolutely conscious that the position does not matter, for nobody is above the law, but the learned magistrate should take note of the allegations in the entirety, the date of incident, and whether any cognizable case is remotely made out. It is also to be noted that when a borrower, this my lord deals with the facts, my lord. Then again, my lord, 28 also deals with the specific facts of this instant case. Then
Just 1 second.
Yes, my lord.
Yes.
My lord, then we can come to the next page, paragraph 29, my lord. Here 154 comes. This probably is the earlier paragraph which has been referred to in paragraph 31.
Yes.
At this stage, it is seemly to state that power under section 156(3) warrants application of judicial mind. A court of law is involved. It is not the police taking steps at the stage of 154 of the code. A litigant at his own whim cannot invoke the authority of a magistrate. A principled and really aggrieved citizen with clean hands must have free access to just invoke the said power. It protects citizen. But when pervert litigations takes this route to harass their fellow citizens, efforts are to be made to scuttle and curb the same. So is 154.1 and 154.3 being made mandatory is, my lord, to probably for the intention of achieving this ends, my lord. Paragraph 30, in our considered opinion, a stage has come in this country where 156(3) applications are to be supported by an affidavit duly sworn by the applicant who seeks invocation of the jurisdiction of the magistrate. That apart, in appropriate cases, the learned magistrate would be well advised to verify the truth and also can verify the veracity of the allegations. This affidavit can make the applicants responsible. We are compelled to say that such kind of applications are being filed in a routine manner without taking any responsibility whatsoever, only to harass certain persons. That apart, it becomes more disturbing and alarming when one tries to pick up people who are pressing orders under a statutory provision which can be challenged under the framework of the said Act or under Article 226 of the Constitution of India. But it cannot be done to take undue advantage in a criminal court if somebody is determined to settle scores. Then, my lord, 31.
Ultimately, in this case, it was quashed because of section 32 of the Sarfasi Act.
32, my lord, that is on marriage. That is on marriage. But principle with regard to, my lord, procedure under 156(3) is laid down in paragraph 31.
Yes, but non-following this would lead to quashment.
Yes, my lord, there are subsequent rulings, my lord, which make it clear,
Alright.
my lord. If we move ahead and, my lord, then
Yes.
possibly come back to
Yes, let's go ahead.
my lord, the next judgment of the Apex Court, my lord, 22 5 SCC 639, Babu Venkatesh, my lord. Here at
Same
paragraph
point.
number 26.
Same point.
My lord, same point.
156.3.
Same point, my lord. Yes,
Alright.
my lord.
Yes, para
Only
26.
one paragraph, paragraph 26 at the penultimate page, my lord. 646.
Yes.
Paragraph 26. This court has further held that, my lord, referring to Srivastava, this court has further held that prior to the filing of a petition under section 156(3), there have to be applications under section 154(1) and 154(3) CRPC. This court emphasizes on the necessity to file an affidavit so that the person making the application could be conscious not to make a false affidavit. So, my lord, here it has been spelled out, my lord, that prior to filing of an petition under 156(3), there has to be prior applications under 154(1) and 154(3).
Here the affidavit is there.
Well, in my case, affidavit is there, but in the affidavit, the required thing is the very reason the affidavit was brought in, so that on oath the person declares that I have resorted to the measures and I have not found any remedy. So that paragraph is not there, my lord. Then, my lord, the next one, my lord, this is the
Which
primary.
page is the affidavit in your case?
My lord, page number 24 in the petition.
Page number
24.
24. All right. Yes. Next.
Next, my lord, this one is on the point of, my lord.
This is from our from this court.
From this high court, and this, my lord, identical case as ours, my lord. So, my lord, I'll seek lordship's indulgence to take you through the facts, my lord.
Yes, please.
My lord, here what had happened, my lord, the complainants, that is the respondent number 2, my lord, in this case, Guwahati High Court case, my lord, they were aggrieved and they brought in allegations against the petitioner, Archana Verma, that she and other officials have indulged in corruption with regard to municipal funds. And here the complaint was filed before the special judge as a magistrate. So, my lord, that procedural lacuna in this case is not there only. What I am, my lord, assailing here. Subsequent to this, my lord, here the point of 156(3) was discussed by his lordship, and, my lord, the order of registration of FIR and the FIR itself was quashed because there was no prior sanction. So this judgment, my lord, I am using for 156(3)'s mandatory nature, as well as, my lord, mandatory requirement of sanction, which is not there in my case. My lord, para 6 onwards, my lord, because para 6, my lord, here it starts with that one under 156(3), because if it is a FIR directly, yes, my lord. The learned counsel appearing for the petitioners in the other criminal petitions aforesaid, while adopting the argument advanced by Mr. N. Datta, learned senior counsel, who have submitted that the order is hit by section 19 of the PC Act, as in my case, my lord, and section 156(3) CRPC, and as such, the same is liable to be set aside. Mr. K. Munir, learned additional PP, has fairly submitted that for initiating a proceeding under this PC Act, sanction under section 19 of the PC Act is mandatory, and the order passed under section 156(3) CRPC should indicate the reasons for passing such direction. So, my lord, if it is a direct FIR under 154, then, my lord, investigation can go on. However, at the submission of the charge sheet or anywhere, my lord, where the stage of taking of cognizance comes before the special judge, by that time the sanction has to come. Sanction at the time of registration FIR, if it is a direct FIR under 154, then it is not mandatory. But, my lord, Anil Kumar, subsequent to Anil Kumar in 2013, if the FIR is registered on the direction of a magistrate's order, because, my lord, even if it's pre-cognizance, a judicial order is passed, and on the basis of judicial order, if the FIR is registered, then it is different, my lord. Then at the time of registration of the FIR itself, the sanction will be required. And in this case, my lord, there is no prosecution sanction. That is an admitted fact, my lord.
Here, sanction will be required at which stage?
My lord, sanction will be required for the registration of the FIR.
In this,
Yes, my lord.
in,
my
in
lord.
the facts of the
For
present
investigation,
case.
yes, my lord.
Once the but there is a judicial order directing inquiry.
Yes, my lord. Directing investigation.
Investigation.
So, my lord, yes. If that, then the Lanka police station, if probably, my lord, setting aside the Priyanka Srivastava requirement, then the Lanka police station should have gone to the appropriate authority. So, whoever is the appointing and removing authority of the petitioners, he has to bring in the sanction, and only after that the FIR number could be registered, my lord.
Okay, fine.
So, paragraph 6, paragraph 7, my lord. Here the Anil Kumar judgment, which I am relying, my lord, for the twofold requirement of the special judge being the appropriate authority, and my lord, the sanction requiring. Paragraph 7, my lord, our High Court had discussed Anil Kumar's judgment. In the case of Anil Kumar and others, the learned special judge, on receipt of a complaint, directed the Deputy Superintendent of Police Karnataka Lok Ayukta in exercising power under 156(3) CRPC to cause an investigation in respect of allegations of corruption made in the complaint against the public servants. The allegations involve offences under the Penal Code as well as under the PC Act 1988. Agreed by the order passed by the special judge under 156(3). Here the forum was not wrong, my lord, in Anil Kumar's case. It was in Karnataka, it was the special judge only. So that they have not assailed. The accused persons approached the High Court by filing a writ petition. The High Court, after hearing both the parties, held that the learned special judge could not have taken notice of the private complaint without sanction, irrespective of whether the court was acting at a pre-cognizant stage or post-cognizant stage. This is important, my lord. Accordingly, the High Court quashed the order passed by the learned special judge as well as the complaint filed against the appellants. High Court quashed the learned order passed by the special judge, that is the order of directing the registration of the FIR, as well as the complaint filed by the appellant. Agreed by the said order, the matter was taken to Supreme Court by filing the appeal. So, my lord, the complainants had gone to the Supreme Court in this. While dismissing the appeals, the Supreme Court upheld the order passed by the High Court. The Supreme Court, while discussing the scope of 156(3) CRPC, observed as follows. The scope of above-mentioned provisions come up for consideration before this court in several cases. This court in Maqsood Syed case examined the requirement of the application of mind by the magistrate before exercising jurisdiction under section 156(3) and held that where jurisdiction is exercised on a complaint filed in terms of 156(3) or section 200 of CRPC, the magistrate is required to apply his mind in such a case. The special judge / magistrate cannot refer the matter under section 156(3) against the public servant without a valid sanction order. The application of mind by the magistrate should be reflected in this order. The mere statement that he has gone through the complaint.
Application of mind would mean that whether the allegations in the complaint prima facie to that
Yes, but reasons,
test it to be true and see whether they make out the case.
Yes, my lord. Yes, my lord. But maybe a step more, because the next line, my lord, addresses
without
lordship's
a
query.
valid sanction order.
That we don't know. Without a valid sanction order, that is there. The application of mind by the magistrate should be reflected in the order. Now, what is the application of mind? The mere statement that he has gone through the complaint documents and heard the complainant as such, as reflected in the order, will not be sufficient.
Correct. That means there has to be some some more
finding then going through the
in
document.
the order itself, which would indicate that on the basis of such allegation, a case under 420 is made out, or something like that.
Yes, my lord.
Which would indicate that the
for this reason,
judicial mind of the magistrate has been exercised. Otherwise, mere writing that heard
I have gone through the documents,
and a case exists will not.
That is exactly in my case, my lord. Here stated I have gone through the
your case. You see, if you go through the complaint, the allegations,
yes, my lord,
and you take them to be true, then a case is made out.
Yes, my lord, but on the basis of the materials, my lord, maybe supporting materials.
Correct.
Maybe work orders.
Therefore, to say that he has not applied mind will not be correct.
Yes, my lord.
All right, technically you are right.
Yes, my lord.
That in the order it is not mentioned.
Not
But if
mentioned.
you see the complaint, it appears
Yeah.
the case is made out, irrespective of the other procedural infirmities that you are
Yes,
bringing
madam.
in. So that is a different thing. But on as far as the merit, as far as the allegation in the complaint, prima facie, there perhaps.
Perhaps appear, my lord, that
In
is,
fact, that
of
is why
course,
you have not argued also on that.
to lordship discretion.
Neither on the
My
other
lord, because there
occasion
we have to
nor
go into
today.
evidence.
You are not going to the averments made in the complaint, right, Mr.
Yes, my
Vaidya?
lord.
You are on the technical issues.
Yes, my lord. Technically, because my lord, lordship is stating that it appears to be application of mine on the part of the JMFC Hojai. My
No, why
point
I am
is that, my
saying
lord,
that is that when you test the order directing investigation,
my lord.
you will also have to be alive to the allegation that has been made in the complaint.
Yes, my
correct?
lord. Yes, my lord.
This court is not going to blindly exercise the
Yes, my lord. Because
power.
because
So,
yes, my lord.
if the allegation in the complaint indicates
Yes, my lord.
that there is material, there is prima facie
Yes, ma'am.
evidence, then why should this court intervene? Of course, in a given case, when the allegation itself shows there is nothing,
Yes.
then this court will certainly.
But my lord, in violation of mandate of law, that cannot, my lord. My lord,
That
if
is a different aspect.
is seeking
That is your
maintenance-
another
yes,
argument.
my lord. Yes, my lord. So lordship is stating that it may be, it appears that there is application of mine, owing that it is stated that he has gone through the complaint and the complaint petition itself is elaborate enough.
Correct.
My primary argument is that, my lord, the concerned magistrate, with all due respect, my lord, he is
Ought
not
to have.
authorized to. He is not authorized to apply his
That
mind in the first
is a
place.
different thing. You see, you are making too many alternative arguments.
Yes, my lord.
Uh,
My lord, those merit, my lord, not my primary, my lord. If your lordship goes there, then it is there. But not primarily, my lord.
Understood, Mr. Paidya.
Yes. Primarily, my lord, 154.1 and 154.3
That of
compliance.
course, I am yet to hear the other side.
Yes, my lord.
Otherwise, looks like the requirements of 154.1 and 154.3
Have not
are
been met.
mandatory,
Yes, sir.
and evident that in this case it has not been resorted. Number
Yes,
one. Number two, that affidavit has to be there indicating all this. This is why the requirement of an affidavit has been brought in. It appears prima facie, subject to what the other side says.
Yes, madam.
Those informations obviously will not be there because that has not been done.
Yes,
Correct. So on that, as of now, it looks you have a case.
Yes, madam.
And that
And my lord, subject to what lordship has just put forth, my lord, that if it prima facie appears that allegations are made out, but on technical points, my lord, this court had blanketly will not exercise power. My lord, there are instances, my lord, in judgments subsequent
and
to this.
also about directing investigation at that time, a valid sanction order should be there.
Yes, my lord.
This is what you are
That is
saying.
mandatory, my lord. Yes, my lord. That is the mandate of law, my lord, because in these cases also, my lord, cases amounting to crores and crores of rupees, but quashed, my lord, sanction not there.
Right.
These are mandatory requirements. And my lord, 482, under 482, my lord, the power of this court is, my lord, immensely vast. And my lord, in the interest of justice, my lord, there are instances where, my lord, because of non-compliance of mandatory provisions of law, my lord,
Vast,
complaints
but,
have been quashed.
It will be exercised only in exceptional cases.
Yes, my lord. My lord, it was, but my lord, it has been observed that, my lord, the aggrieved person or the informant or the complainant may take proper recourse, my lord, that he can go and file an FIR again, my lord. Proper recourse, my lord, the informant or the complainant can definitely take, my lord. Now, my lord, continuing our High Court judgment.
Yes.
So here, my lord, the under 156.3, the complaint was registered. And addressing that, my lord, we were at page number 4, my lord.
Yes.
7th line, my lord. Because here also the magistrate has stated, my lord, that he has gone through the documents and FIR. So what the apex court in Anil Kumar had held is that the mere statement that he has
See,
gone
the
through the
sanction
complaint
will only
document.
come to petitioner 3 and 4. Right?
Yes, my lord.
That is only 3
Yes, my
and
lord.
4.
But if we lordship goes into the merits and if 120B is there, then, my lord, if 3 and 4 are not in the picture, 1 and 2, my lord, cannot commit this offense.
All right. So, yes, come to 9.
That line, my lord, that mere statement that he has gone through the complaint documents and heard the complainant as such reflected in the order will not be sufficient. Here, my lord, on that, even though it's there in the complaint, why
Yes,
the magistrate has found
read.
the application of mind by the magistrate should be reflected in the order.
No, that you have.
May I leave for a 10 minutes, my lord?
The application
After going through the complaint, just below.
yes, my lord.
After going through the complaint,
After going through the complaint, documents and hearing the complainant, what weighed with the magistrate to order investigation under 156(3) CRPC should be reflected in the order. Though a detailed expression of his views is neither required nor warranted. We have already extracted the order passed by the learned special judge, which in our view has stated no reasons for ordering investigation. So in this case, my lord, it was held to be not sufficient. Now, coming to the High Court's observation, my lord. From the above, there is no difficulty in understanding that an order passed under 156(3) CRPC for causing investigation in respect of offences under PC Act must be preceded by a sanction order as required under Section 19 of the PC Act. Though the special judge or a magistrate, as the case may be, have power to pass an order for investigation under Section 156 CRPC, the requirement of sanction as provided by Section 19 of the PC Act cannot be dispensed with. Therefore, sanction under Section 19 of the PC Act is a prerequisite even in the case of a definite complaint against an erring public servant. 8. In the case of Ramdev Food Production, the order of the magistrate. 8, my lord, deals that it has to be reasoned order again, my lord. I'm taking your lordship, not taking your lordship there. 9, my lord, 154(1) and 154(3) again dealt with. In the case of Priyanka Srivastava Supra, the Supreme Court, referring to the case of Anil Kumar, Dilawar Singh and Lalita Kumari, has observed that the power under 156(3) warrants application of judicial mind and that the litigant at his own whim cannot invoke the authority of the magistrate. The Supreme Court has also held that there has to be prior applications under Section 154(1) and 154(3) CRPC while filing a complaint petition under Section 156(3) CRPC, and that the application under Section 156(3) CRPC is to be supported by an affidavit. Paragraph 10, my lord, deals with an identical judgment of our High Court only. That, my lord, is not available online. Certified copy also I have applied, my lord, but unable to obtain, my lord. 2014 judgment on this line, my lord. This is one Rajiv Kumar Bhuya judgment. I am able to find the criminal petition number as well, my lord. It is criminal petition number 76 of 2014. However, my lord, certified copy, it's been about a week, my lord. The record is not being able to be traced. But on that basis, my lord, this was also passed. So, coming to paragraph 11, my lord, this is the rationale. Agreed by the said order, the accused petitioner approached this court by filing an application under 482 CRPC. This court by order dated this referring to
you
the decision.
did not get this decision, Rajiv Kumar Bhuya.
No, my lord. Rajiv Kumar Bhuya is just prior to this judgment. Rajiv Kumar Bhuya, my lord, finding is discussed in paragraph 11.
Yes, I have read it.
That is there. So what has happened, my lord, conclusion in this, in view of the above discussions laid down by the Supreme Court and the statutory provision, it is found that the learned special judge passed the order under 156(3) CRPC mechanically without applying his mind and without recording the reasons warranting a direction under Section 156(3) CRPC. That apart, the impugned order was passed without prior prosecution sanction under Section 19 of the PC Act, which was a mandatory statutory requirement in respect of the petitioners who are public
I've
servants.
read it, Mr. Vaidya.
Yes, my lord.
Next.
So next, my lord, this is the Bombay High Court judgment, my lord. Paragraph 7 and 9, my lord.
Paragraph 7. This is on
7 and 9, my lord. 156(3) vis-a-vis 154(1) and 3, my lord. Just paragraph 7. It's a one-line paragraph. I'm reading it out. It is by now settled position that the complainant must exhaust the remedy available under 154(1) 154(3) before approaching the magistrate under Section 156(3).
here that liberty is given. Para 9.
Yes, my lord. Para 9. That is the thing, my lord. That he can go, my lord, but it is quashed, my lord. Not that it,
Yes,
it is
I've seen
rectified.
it. Next.
My lord. Then The next one, Calcutta High Court, my lord, paragraph 16 and 17,
On
my
which
lord.
point?
My lord, same, my lord. Next, 4-5 judgments are on the
Why so many
154-3.
decisions on the same point?
My
Mr.
lord,
Vaidya?
because courts have gone into the fact at times, my lord, that
I
whether this
was
can be
hoping to
considered
give
as
the
a...
judgment in the court.
Yes, my lord.
By
That,
you don't need so many judgments
Lordship
for
may
one
bypass
case.
the next...
One judgment, one point.
My lord.
That
Lordship
simplifies
may...
and makes it easy for the courts to give the judgments.
My lord.
Yes.
My lord may then bypass the next 3 judgments, my lord, and come to, my lord, 2016 Bombay 4867, my lord. 2632 is paragraph 9, 10 and 13, my lord.
One second, because you have not paginated. This 23 Bombay is also on 156.
Yes, my lord. Yes, my lord. 23 Bombay. That is 4 pages.
Jai Kumar.
Jai Kumar, same, my lord. Paragraph 11, 12, 13. Mandatory. Then, my lord, 2016.
Yes.
Enercon.
That's also 156.
156.3. But here, my lord, only one paragraph I'll draw your lordship's attention. Here in paragraph number 6, this issue has been gone into by the Honorable Court as to whether non-compliance of 154.1 and 154.3 can be considered to be a mere irregularity. The
Yes.
informant
And what
has
is the finding?
agitated, my lord. The finding is at paragraph 11, my lord, that that is not the case, and 154.1 and 154.3 are mandatory in nature. My lord, the court has gone into this question in paragraph 6.
Para 11.
Paragraph 6 and paragraph 11 is the finding in the negative, my lord, that it is not a mere irregularity, it is a mandate of law. Cannot be rectified or bypassed.
They've referred to Priyanka Srivastava.
Yes, my lord. Yes, my lord. My lord, the next judgment is of our High Court only, Tarun Dev Sharma.
And here also they have quashed.
Yes, my lord.
So suppose this court is with you in on the first point, then this court need not go into the other issues.
Yes, my lord.
Suppose this court comes,
yes,
because this appears to be an admitted fact.
Yes, my lord.
It's a purely a point of law now.
Yes, my lord.
And it appears it is already settled.
Yes, my lord.
So suppose, I'm yet to hear them, but if this court is of the opinion that 154.1 and 154.3 are mandatory compliance, failing which the entire proceeding can be vitiated,
Yes,
then this is the right stage to correct it. Why to wait for a trial to conclude and then?
Yes, my lord.
Because this will ultimately correct. It will ultimately make the entire case of the prosecution fatal.
Yes, my lord.
So this is the right time, and give the liberty if needed.
Yes, my lord. Yes, my lord.
This is one that is going on in my mind.
Yes, my lord.
I'm expressing it so that parties may ponder upon it. Yes.
The next judgment is, my lord, on the same lines. Here, my lord, it was held that it is mandatory. However, my lord, yes, my lord, Tarun Dev could not have been applied because Tarun Dev's FIR was prior to Priyanka Srivastava's judgment coming into effect.
Why do you need it then?
My lord, but the observation, my lord, and this, my lord, I had found at the first point of time. Subsequent to my lord, lordship's anxiety, my lord, the other judgments.
You've already addressed my anxiety.
Yes, my lord, then lordship may come to the, my lord, penultimate judgment, my lord, that is with regard to the sanction, my lord.
That the earlier decisions also show sanction is needed.
Yes, my lord. My lord, that is the Anil Kumar's judgment.
Yes.
Apart from sanction, Anil Kumar already discussed by Lordship Honorable Justice C.R. Sharma in the 2015 judgment. But Anil Kumar, because our High Court judgment, this issue was not there because the forum was correct, my lord. Special judge only has passed. But application of mine and sanction not being there were the issues.
Paragraph.
My lord, penultimate Anil Kumar judgment, paragraph number 15, my lord. 16, my lord, sorry. Internal page 712.
No, now you are in which decision?
No, my lord, I've come to the penultimate judgment because rest are all this.
Okay,
Lordship
just one second. Let me just mark them. Then Antule is for
Antule, my lord, that issue already Lordship has decided, my lord. The
then
special judge is the appropriate forum.
this is for that part.
For that part, my lord, Antule. 34 and 35 paragraphs.
And then
After Antule, my lord, Anil Kumar, my lord.
one second. Yes, Anil Kumar.
Anil Kumar, my lord.
Yes.
Anil Kumar's paragraph 16, my lord.
Yes,
At
this
page
is
number
on the point.
712.
What is the issue?
My lord, that the judicial magistrate first class could not have passed this order. Even if my lord takes that Priyanka Srivastava's requirements are not mandatory, or if he can, my learned counsel for the opposite party may submit that he has filed an FIR and a letter to SP,
Yes.
even then the magistrate ought not to have or could not have, my lord. Paragraph 16, last line, my lord. The magistrate who is empowered under section 190 to take cognizance alone has the power to refer a private complaint for police investigation under section 156(3) CRPC. This, my lord, Antule and the previous judgments have made it clear that the special judge is the magistrate who is empowered under 190.
Yes.
So this goes, and my lord, I will not repeat the sanction or part because that has been discussed already in the, my lord.
What is
Guwahati
this
High Court
Madras?
judgment. Madras High Court is the same, my lord. Paragraph 7 to 15 deals with this Anil Kumar's
Special judge.
Yes, my lord. The special judge is the appropriate forum. And my lord, 35, 36, 37 deals that
Sanction.
prior sanction is mandatory at the time of registration of FIR, provided it is done by the means of 156(3).
Yes.
That is all.
Yes. 2 o'clock? Where's your senior gone? Right, we can reply at 2 then. Mr. Kaushik, you are also there in this matter?
Yes.
Yes. What is your submission?
So far, Priyanka Srivastava is clear. And
You may be a formal party, but the issues that have been raised are purely law points involved. So, what is your submission to that? What about the compliance under section 1541 and 1543?
going by the record, by the 154 complaint was not there.
Is not there.
And Priyanka Chopra judgment, and subsequently another judgment 2015, Ladder has already submitted that.
Come this side.
That is clear in this point, but I was fairly submitted.
So you have gone through the record. 1541 is not there, correct?
Not there, madam.
And 3 also will not be there.
No, it will not be there, madam.
That affidavit, let us see that affidavit. Where is the
But
affidavit?
the order that mentioned in the so far the impugn order is concerned.
That itself mentions.
Itself mentioned they gone through the affidavit. madam.
Gone through the affidavit.
The first line itself.
No, but where is that affidavit?
Page 24.
Because you have heard that affidavit has to be in terms
Yes,
of
yes, because of Srivastava.
page.
Minor page 24, my lord.
Yes.
They-
Nothing is mentioned. There's a very
Actually, they should have in a separate page.
this is a general affidavit of oath which you generally append. You put it in the repetitions and all. It is a simple oath affidavit.
Knowledge and
So, you see, the query that I am posing to you is,
Yes.
admittedly, 154.1, 154.3 has not been done.
Not been done, madam.
And sanction also perhaps is not there.
Yes.
On these point itself, on these 2 points alone, this court can quash the proceedings.
Yes, there are procedural assessment.
There is, these are
Not
not
going
procedural,
into the
these
merit,
are
madam.
non-compliance of mandatory provision.
Yes, madam.
The complainant could not have resorted to 1563
Yes,
without first resorting to 1541 and 3.
Yes.
Correct?
As per Priyanka Srivastava. So far, by that,
So then, without further delay, it's, let us correct that error right away.
they can file a FIR now.
They can do whatever they want to do after this.
Yes, madam. And one aspect when I like to point out, this will not come perhaps if your lordship process it on the basis of 156.3, then this will not come, but just I want to show it, my lord. Section 5 of PC Act, my lord.
Yes, please read.
That is, special judge may take cognizance of offense without accused being committed to him for trial and trial. My lord, what?
Read it clearly, Mr. Kaushik.
Actually,
both powers of the
section 4.
Yes.
Subclause 2.
This is for the whether it has to be by the special judge on
Yes,
that.
yes.
Yes. Subsection 2.
Subsection 2, my lord.
Yes.
Every offense specified in subsection 1 of section 3 shall be tried by the special judge for the area within which it has been committed, or the case may be special judge appointed for the case. Why I'm saying, my lord? Because the word is here tried. The word is here is tried.
Tried.
Yes.
Yes.
Because now the
So according to you, this is in the subsequent stage.
so police can find the search sheet in the special judge.
But you see, if I hold that the direction for investigation and the consequent decision of the FIR is not in tune in the view of Priyanka Srivastava, then I don't think I need to travel to all these points, because it will be unnecessarily make the things complicated. Correct?
Yes.
My lord, what he has posted, my lord, which I was academically speaking, my lord, in the Act only, if your lordship goes to the presently applicable Prevention of Corruption Act, here, my lord, in the proviso only, it has been explained, my lord, that magistrate cannot take cognizance in offences specified under section 3(1).
Where?
My lord, in the Bare Act itself, my
Yes,
lord.
I have the Bare Act.
My lord, under section 4.
Yes.
Once the subclause 4 ends,
provided
jurisdiction of special judge, one heading.
Oh, that is a comment. Now
Yes,
you're going
sir,
to take
that
me to
part,
the
that
commentary.
That part, my lord, that part, it has been
You
clarified.
said it with so much conviction. I thought it was part of the proviso.
No, not proviso, my lord. Apologize, my lord.
This is the second time that has happened in this court in the last 2 days. Advocates have started taking me to the commentaries. Commentaries are commentaries of the author.
In any case, this will not come now if your lordship go by the 156.3.
Get hold of that decision, Mr. Vaidya, during the break.
Yes, ma'am.
That Rajasthan decision. But if I am on, let's see what the other side has to say, because in my opinion, a substantial time has already been gone.
Yes.
So I don't think it makes sense of sending it to trial and later on the entire conviction or acquittal, whatever be because of this procedural lapse.
And in fact, my lord, to the humble submission, since from inception it is not correct, my lord, and there is no question of sending it for trial also.
That is what. All right. Continue at 2. PC এক দুখন টো দিলে দুখন আহি ইয়াতে আছে Yes.
My lord, in this case, my lord, admittedly, my lord, there is some procedural lapses in the whole issue, my lord.
Yes, that is why what I was thinking, it appears that 154.1 and 154.3 has not been resorted before filing the 156.3 complaint, correct? Admitted position. Now, in that view, if I can quash the proceedings and give the liberty that you file appropriate FIR That can be one way.
My lord, one point, my lord.
Hmm.
My lord, the procedural lapses admittedly, my lord, visualized in this case with regard to section 7 of PC Act, my lord.
Hmm. What about 154, 1 and 3?
My lord, I mean to say, my lord, there are other panel sections, 420, 468, 409 also there. And there are two categories of persons, my lord, involved in the complaint, my lord. Two persons, they are, my lord, government servant, and other two, my lord, general person, my lord. My lord, the procedural lapses, my lord, with regard to section 7 of PC Act, my lord. Again, the, my lord, government person, my lord. And my
That
lord,
is sanctioned.
yes, my lord. And other two persons, my lord, they are general persons, my lord. The IPC section, my lord.
I've understood, but before you are addressing the issue of sanction, first you reply to the first argument.
Yes, my lord. Sanction part.
What
that is, my
about
lord.
compliance under 154.1 and 154.3?
Yes, ma'am.
Because the additional PP has fairly submitted before the court that the records indicate that these two provisions were not complied.
Yes, my lord. The sanction.
No,
The
no,
section-
not sanctioned.
My lord, that is filing of an FIR before the officer in charge
Yes, my lord.
and the
Thereafter,
superintendent of police
yes.
respectively. And that is not limited to the PC Act, my lord. That
Correct.
is same to the IPC offences as well.
So that is the first argument which was made. Second is about the sanction.
Sanction. Yes,
Now,
my
as far as the first argument is concerned, Priyanka Srivastava.
Yes, my lord. No complaint, my lord. Complaint has been filed before the FIR has been lodged before the police, my lord. But in the affidavit, only he did not say that I approached the concerned police station and thereafter I.
No, 154, 1 and 3 is there. It's not there.
No, my lord. That's not
3,
there.
my lord. 150, 56, 3, my lord.
154 3.
154.3. Any person aggrieved by a refusal of part of an officer in charge of a police station to record the information referred to subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who is satisfied and such information discloses the commission of cognizance offense, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to
So
him.
here this was not done.
Yes, my lord. That is why, my lord, outset of the case, my lord, I admitted that there are some procedural lapses.
Mr. Counsel, you did mention at the outset about the procedural lapses, but you were referring to section 7.
Yes.
That is the second argument. First, if you admit that 154.1 is not complied.
My lord.
You admit,
Yes.
correct?
Yes.
154.3 also not complied.
Yes, my lord.
You're admitting it. You see, you are conceding to this. Now, the moment you concede to these two things, then automatically the order of the magistrate, order of the JMFC, directing the investigation and the consequent registration of the FIR becomes bad. Correct. Now, in that course, what probably would be in the interest of the parties is that this court quashes the order and the registration and gives liberty to you to file FIR fresh if need be so.
Yes, my lord.
Then you file it in terms and all the procedures will be met with. I think this is one course which this court can do instead of simply quashing it. I can quash it and not do anything also.
That is his prerogative if you want to
Correct,
file
because you don't need a liberty from this court to file another FIR. But since you are conceding,
yes,
then I may not go into a lengthy argument I may not go into details of the arguments made, and I can. Choice is yours.
My lord, this is a case of my
Because
lord, 2000.
admittedly, the EPP also admits. You are also admitting. Then if that failure is there,
Yes, my lord. That
see,
part
then
is
those
there.
decisions which Mr. Vaidya has relied.
My lord, this is a.
That's because he has not.
My lord, this is a case of.
All
my
right.
lord.
Anything else? Because
My lord.
on one, if I am going to give a decision on this, then I don't think I need to go to the other points argued by
Yes,
Mr. Vaidya.
yes, my lord. My lord.
So you
only
please.
one point, my lord. This is a case of 2019, my lord. 2018, my lord.
Yes.
And after a prolong of time, my lord, if he approached the concerned, my lord, police station or whatever, my
Mr.
lord.
Counsel, please answer with this. If today I do not quash this and I allow the trial to go on, I allow the trial to commence, tomorrow when you get an order, for some reason it is in your favor, and that order is put to appeal, then because of non-compliance of these mandatory provision, that conviction would be set aside. Do you want that kind of a situation when admittedly you are agreeing that the mandatory provisions, prescriptions of the law has not been followed?
Presumption. That is presumption, my lord.
No. What presumption, Mr. Counsel? You are admitting that 154.1 and 154.3 is not complied. Is there any difficulty for you to understand what the court is saying? You are admitting to that position. If that be so, then by the law laid down in Priyanka Srivastava and the subsequent decisions and also of our High Court, it is very clear these are not a mandatory provision. Non-compliance will make the entire FIR bad. Then
My lord, an opportunity may be open to the my lord complainant.
Mr. Kaushik, where was that you referred to the records, and it has come from which statement recorded under?
He has not stated that I have to not.
No, he has not stated that where.
That is in affidavit, my lord. That should be there, but that is not there in the affidavit.
Record also. In his statement under 161, he has not mentioned anything about it.
That is what I'm asking. 161. Where is that liberty that you had shown?
Lordship, the judgment, my lord,
Yes.
Bombay High Court.
Which one is that? The Bombay High Court?
Yes, my lord. My lord, that one is after the Guwahati High Court judgment.
Yes, I've got it.
My lord, Lakshmi R. Kardhakar.
Yes, I've got it.
Yes,
Take down. Item 15. Huh? heard Mr. D.K. Vaidya, learned counsel for the petitioner. Stop. Also heard Mr.
Yes. Yes. Yeah.
S.A. Ahmed, learned counsel for the respondent number. For respondent number 2. For respondent number 2 and Mr. K.K. Kaushik, learned, Mr. R.R. Kaushik, learned APP for the state respondent. Stop. By filing this application under section 482 of CRPC 1973, the petitioner is seeking quashing of the impugned order dated 21/1/2019 passed by the Learned Judicial Magistrate First Class, Hojai, directing the registration of the FIR in Lanka PS case number 105 of 2019 registered under section 150, no, not registered, under section 156 within bracket 3 CRPC, and the consequent FIR in connection and the consequent registration of the FIR being Lanka PS case number 105/2019 registered under section 420, 468, 409 of the IPC, read with section 7 and 13(1)(c)(d) of the Prevention of Corruption Act. Stop. The case of the prosecution in brief is that on 17/9/2018, the complainant filed a complaint petition before the Court of Learned Divisional Judicial Magistrate Hojai, alleging inter alia that the FIR mentioned accused / petitioner numbers 1 and 2 submitted false bills for building materials for the construction of Bharat Nirman Rajiv Gandhi Seva Kendra building under Kondura Buragaon GP for 2016-17 and 2017-18, and a false completion report was provided by the concerned JE, and public money was misappropriated in connivance with the JE and the BDO. Stop. It is further alleged that the petitioner numbers 3 and 4 also submitted false inspection reports regarding 4 numbers of road improvement work under MNREGA scheme, and money has been released to the petitioner numbers 1 and 2 without supplying any materials. Stop. My trick. This is It is further alleged that sanctioned money regarding improvement of a road from Chitan Kathar's house to PMG Road has been misappropriated by the accused persons in connivance with the then postmaster of Sankardev Nagar Post Office. Stop. Mr. D.K. Vaidya, learned. Before that, Okay. Mr. D.K. Vaidya, Learned Counsel for the petitioner submits that the jurisdictional magistrate that the order of the jurisdictional magistrate in directing investigation under section 156(1) 156(3) of the CRPC is erroneous in law inasmuch as the complainant has resorted to section 156(3) directly without resorting to the provision of section 154(1) and 154(3). Stop. He further submits that non-compliance of section 154(1) and 154(3) being mandatory provision, comma, the order of the jurisdictional magistrate impugned in the present revisional petition is totally erroneous in law. Stop. He accordingly submits that the consequent registration of the FIR is also erroneous. Mr. R.R. Kaushik, Learned APP, submits that it is evident from the statement of the complainant recorded under section 161 CRPC by the investigating officer, which is available in the where, Mr. Kaushik? Which is available in the case diary, comma, that he has not stated that he has approached before the police officer before the jurisdictional police under section 1541. Stop. 1543.
1 and 3.
1 and 3. 1 and 3. Stop. Mr. S.A. Ahmed, Learned Counsel for the respondent number 2, fairly submits that the complainant has not resorted to the provision of sections 1541 and 1543 prior to filing the complaint before the magistrate under section 1563 CRPC. Stop. It is by now well settled that complainant must exhaust the remedy available under section 1541 and 1543 before approaching the magistrate under section 1563. Reference in this regard is made to the decision of the apex court in the case of so-and-so, reported in 2015, volume 6, SSE 287, 2022, volume 5, SSE 639, that GLR is 2015-4.
15 volume 4.
2000, stop. Reference is also made to the decision of this court in the case of so-and-so, reported in 2015, volume 4, GLR at page 1. paragraph 30, 31, 35 of Priyanka Srivastava, within bracket Supra, is reproduced here under for ready reference. Priyanka Srivastava to first case, 2015 6 No, Priyanka Srivastava is 30, 31, 35, right?
My lord.
Paragraph 30, 31, 35.
My lord. 30 and 31.
30, 31.
30 and 31.
What is to be stated in that FIR, in the affidavit, Mr. Vaidya?
Affidavit or the application, my lord, needs to contain that I have filed an FIR before so and so police station and I have got no response. Then I have gone to so and so superintendent of police, have got no reference.
In the present case, the accompanying affidavit in the complaint petition within bracket CR case number 1050 of 2018 does not indicate as whether the complainant has approached the jurisdictional police before filing the complaint in the court of JMFC. Before filing the complaint before the magistrate court. Stop. A copy of the said affidavit is reproduced here under for ready reference. Page 24, quote unquote, A to A. It further appears that the complainant, while being examined under section 161 CRPC, has also not stated anything as regards approaching the police station under 1541 and 1543 CRPC before filing the complaint before the magistrate court under section 1563. Stop. Thus, it is clearly established that the present complaint under 1563 is not preceded by applications under section 1541 and 1543. Stop. Therefore, the mandatory prescriptions under section 1541 and 1543 has not been complied with in the present case. Stop. In view of such failure of compliance of the mandatory prescriptions of law, the order of the magistrate dated 21/1/2019 is erroneous. Stop. As such, the same is set aside and quashed. Consequently, the registration of the FIR so and so in citation is also quashed. Respondent number 2, however, is at liberty to approach the in charge officer of the jurisdictional police station under section 1541 of CRPC. Stop. All points and contentions of the parties are expressly kept open, disposed of.
Obliged.
My lord, any subsequent FIR will be dealt in accordance with law, my lord, as per lordship direction.
Mr. Vaidya, it is obvious it will be dealt in accordance with law.
Obliged.
Yes. Yes, Mr. Fukan, for which matter you are waiting?
Lordship, this is the appeal against.
But I'm not sure if this court will have time. It appears there are 2 more part-heard matters.
This is also part of the part.
Yes, I'm not telling you. So you can take your chance, or otherwise you can get it fixed on another date. Choice is yours. Yes.
On Tuesday coming Tuesday.
This Tuesday, I don't think the single bench is available. Any date after Tuesday, you can take it. Yes.
Lordship, the conviction was made under section 376(1) of IPC for commission of rape, offense of rape, 10 years imprisonment.
Who is appearing at the side? You're appearing.
Yes. No, she's maternity leaves.
Huh?
Our senior is maternity leave, sir.
This private respondent.
You had mentioned this matter in the morning.
Yes.
Then why are you not saying it? We are allowing the other side to start the hearing. Actually, there was a mention in the morning, but because we had not taken your consent, this court did not run the adjournment.
Lordship,
Appears that
for last 5-6 times dates, I have not seen her. I have not seen her senior for last 5-6 numbers of dates.
yes, because it appears that she is on maternity leave.
But
Anyway, when can she be available?
December.
December?
Yes.
Lordship, they may be considered maybe fix on December. 2.5
If I
years.
submit, my lord, this is a 376 case, my lord. They are only having participatory right, my lord.
You are there.
Yes, I
So
am.
I'll have it. I'll take it then.
Yes, but because it's a maternity leave, I don't think it will come.
All the evidences are available.
My lord, perhaps one of my learned friend is pursuing 389 petition.
No, the appeal is, I'm taking up the appeal.
Appeal.
I'll dispose of the main appeal.
Then I'll have to go to the record. My lord.
You go through it and I'll have this matter fixed on Thursday.
My lord.
Okay.
So I was in the impression that as my learned friend
No,
told
no.
me,
The criminal appeal itself is going to be taken up. In fact, I remember I have heard it part. Correct?
Yes, Lord.
You had started.
Yes, my lord.
And you may make alternative arrangement till then, next Thursday. As prayed for by Mr. R.R. Kaushik, learned APP for the state respondent, the matter is posted again for further hearing on such and such date.
Obliged.
Item 17.
In this matter, my lord, our part is complete. Mr. Soduri's. I have prepared a short note for her regarding my 14 minutes.
Mr. Borthakur,
Yes, ma'am.
I had seen the case diary
There is a statement of Boban Pathak, my lord. Three
Yes,
statements is there.
but nobody refers to
In one of the statements, with the help of him, my lord, I have seen, my lord.
Mr. Kaushik. But I've also gone through it. Where is Dipshika's name mentioned?
Yes, madam.
No, but what is the mention?
Madam, one
Does
person.
it incriminate Dipshika?
Yes, yes.
Please point it out.
In fact, my lord, she is the sister-in-law of the main accused.
That is all right.
Yes, madam.
But you see, there has to be some allegation pinpointing against Dipshika, which allegation, if taken to be true,
Yes.
makes out a criminal offense.
Yes, madam. And
Correct.
Yes, madam. One thing, madam.
Now, in order to be satisfied that, because you are right,
Yes.
some connection appears,
Yes.
but merely because of suspicion.
No, madam. And one thing is there, my lord. There is a IO note in the last portion. Even after repeated calling, my lord, they were not cooperating because the investigation is in the initial stage, my lord.
Cooperating and all that is
Yes, madam,
different.
that
Please,
is
please
different.
point out it is Rupak.
But in one of the judgment, Supreme Court says, my lord, initial deception, my lord, can be judged by his subsequent conduct, my lord.
All right, I'll come
Yes,
to you,
yes.
Mr. Bodhas. Rupak, লৈ আহাচোন। ভালকে চাই ল'বা এখন জেগা।
কি বুলি আছে?
পৰিয়ালৰ লগত লগ লাগি বুলি
Common intention to assemble.
that Baban Pathak, my lord.
সোনালী ফুডছৰ মালিকী স্বপ্ন নীলম মেধি এলাইচ নীলাংক কাশ্যপ এলাইচ দীপজ্যোতি মেধিয়ে আয়ত্ত কৰে বুলি মোক জানিবলৈ দিছে। দীপশিখা চৌধুৰী হানছৰ MD আৰু
He says that he only knows
No, madam.
that
Next page.
Dipshika is.
No, next page.
Next page.
নীলম মেধিয়ে লগত লগ লাগি মুৰ্গীৰ দানাৰ
But this allegation is against Neelam Medhi.
No, well, there is a word. পৰিয়ালৰ লগত লগ লাগি.
Poriyalar logo. But you
Yes,
see,
madam.
earlier to that he has said
নীলম মেধি দিলংক কাশ্যপ এলাইচ দীপজ্যোতি
this doesn't incriminate anything else, only this.
Only this, and before that also, her husband also verified that they are related, my lord. And because that, why I'm saying, my lord, because their intention must be seen, my lord, because they were initially in a Hudson Food. Subsequently, they created a fake company, Sonali Foods, my lord. They were selling the goods of because this person, Dipshika, was once a consultant of the Hudson Food. Subsequently, she became a director of the Sonali Food. That was kept secret from the Hudson Food. Then they sold the goods of Hudson Food in the name of Sonali Foods. And without the knowledge of the director, it will not be done, my lord. And because, my lord, Lordship has seen, my lord, this director, so Ms. Dipshika, she's related to Neelam, and they all are related, and that has been clarified by the Baban Pathak statement that they are running this whole scandal. It's a kind of family business. The prima facie, they have made out a
All right, let me just have a look at this written note. In fact, this court was only concerned with that, and that is why I wanted to see the case diary. So I had also read it.
Yes.
Apart from saying Porialor Logot, there is nothing else.
Yes.
But maybe that itself also might have significance.
Yes, because why? Because they were keeping that business within themselves. So that part police is investigating, but the investigation is not progressing because they are not cooperating.
Entrustment, Mr. Bhattakur, you are trying to say because she was the overall in
Yes,
charge.
madam. Because the ward is in any manner entrustment, madam. That's why I have so the 34 I have tried to there should be a section of 34 because they shared the common intention. It is not
That is not there.
Yes, my lord. But at the time of filing of charges, they may submit under section 34 also.
Perhaps it may not be an appropriate case to.
I think so, my lord.
At the threshold itself.
Yes, my lord.
Something may come up. But then you see,
but if all the accused person shared a common intention, it's not necessarily everybody is doing the same act, my lord. Only intention must be there, my lord. And kindly see for a moment section 34.
Yes, what?
Section 34, my lord, kindly see.
Section 34, I'm not sure.
Yes, ma'am. Because of the invoice has been issued to the customer, my lord, and the customer has directly they have to remit the amount to the company's account, my lord. But the payment has been made through this Dipsika, my lord. It is there document, my lord, is Annex 9, my lord.
All right, let me first dictate the facts. Let's make a start and let's see how it goes. Ultimately, the test which is laid down in Bhajanlal has to be applied. So after I lay down the facts and everything, let me apply that test and see.
Yes.
Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by
H.A. Ahmed.
Mr. H.A. Ahmed, Learned Counsel for the petitioner. Stop. Also heard Mr. S. Borthakur, Learned Counsel, appearing for the respondent number 2, and Mr. R.R. Kaushik, Learned APP for the state respondent. Stop. By filing the instant petition under section 482 CRPC, the petitioner is seeking quashing of Hatigaon PS case number 264/2023, registered under section 419/406/420 IPC. The facts of the case is that lay down the code slow 1 2 3 4 2 9 The facts of the case are as follows. The petitioner was engaged as consultant of Hudson Foods Private Limited by consultant engagement agreement dated 19/4/2019. To provide services as set forth in Appendix A of the said agreement. Correct?
Yes, sir. Page 33.
And make it continuation. And the company agreed to pay the consultant as mentioned in Appendix B of the said agreement. Stop. Accordingly, the petitioner was working as consultant of the said company since 2019. Stop. It is the further case of the petitioner that the petitioner was discharging her duties as an independent contractor of the company, and the petitioner is not an no, I don't know. Delete that. While the petitioner was working with the said company since 2019, on 8/8/2023, this is the FIR, right? 8/8/23.
Yes, sir. Page 36, ma'am.
Is that page?
36, ma'am.
One Aditya Harlalka / informant lodged a FIR against the petitioner before the Hatigaon police station alleging inter alia that one Nilang Kashyap, under the authority of the present petitioner, placed order of different poultry commodities. Stop. Pursuant thereto, the goods were transported from the factory of the company to the company's Godam at Sonapur, Guwahati. Stop. The stock were received by one employee, Bobon Pathak, but on inquiry, it came to light that the stocks were missing from the Godam, and allegation from the Godam, and accordingly, it is alleged that the petitioner, along with the others, has stolen the goods and sold the products and thereby committed breach of trust of the company. Accordingly, a case has been registered as Hatigao PS case number 264/2023 under section 419-406-420 IPC. Stop. The present petition is being filed for quashing the said FIR. Stop. Mr. Chaudhary, learned senior counsel, submits that on bare perusal of FIR and taking the allegations as correct, a prima facie case has not been made out under section 419-406-420 IPC against the petitioner. He further submits that there are no ingredients to constitute the offences under section 419-406-420 IPC against the petitioner. Stop. He further submits that paragraph 7, I'm flag green, page 2 of written argument of petitioner. He further submits that 8, page 3, same, huh? B to B. He accordingly submits that section 419 and 420 IPC cannot be attracted to hold the person guilty of cheating unless it is shown that he/she had fraudulent dishonest intention at the time of making the promise. He accordingly submits that in the instant case, absence of any such allegation against the petitioner, section 419 and 420 IPC is not attracted as far as the petitioner is concerned. Stop. He further submits that paragraph 9, next 10, okay. Mr. S. Borthakur, learned counsel for the respondent number 2, on the other hand, submits that the FIR, that the allegation in the FIR clearly makes out a prima facie case, and therefore the same warrants no interference from this court. Stop. He submits that the petitioner, being in overall in charge of the northeastern states, operations of the Hudson Foods Private Limited, was also entrusted with procures orders and for entering into rent and lease agreements and the petitioner accordingly appointed the employees in the Guwahati branch office and Godam and the same were de facto in her control as along with her relative Nilam Kashyap. Oh, no. Were de facto in her control, full stop. He further submits that Nilam Kashyap, the prime accused, and Boban Pathak is also a co-accused. Right?
Yes,
co-accused were all appointed by the accused petitioner, and out of them, Nilam Kashyap is a relative of the accused petitioner. Stop. He further submits that the lease deed dated September 5, 2022 for lease of Sonapur Godam was executed by her, and in the process of business, the petitioner has placed the order of the customers to the head office of Hudson Foods at Kolkata, and accordingly goods were transported to Godam at Sonapur from Rani Nagar plant with delivery note, consignee notes and text invoices. Stop. He further submits that it is evident from the records that the said goods were received by Sonali Foods and Feeds Private Limited, where the accused petitioner is one of the directors. And the petitioner concealed the fact that goods were actually received by Sonali Foods and Feeds Private Limited, which is also evident from the consignee note of the transporters, wherein a receiving stamp of Sonali Food is engrossed. He accordingly submits that if the aforesaid, he accordingly submits that an offence under section 415 is clearly made out against the petitioner. He further submits that the petitioner, being entrusted with the goods, the same having been misappropriated dishonestly, an offence of section 4 under section 405 is also made out against the petitioner on the face of the allegation in the FIR. Stop. Correct?
Yes, ma'am.
These are the two main arguments.
Yes, yes.
Mr. R.R. Kaushik, learned APP, also submits that the allegations of the FIR clearly makes out a criminal case against the accused petitioner. Stop. He further submits that case diary indicates prima facie involvement of the accused petitioner. Stop. He further by referring to the statements recorded by the investigating officer under section 161 CRPC submits that. Then the rest. I have given my prudent consideration to the arguments made by the learned counsel for the parties and peruse the materials available on record, including the case diary placed before this court. Stop. Next paragraph. The principles of exercise of power under section 482 CRPC to quash the FIR is well settled by number of cases of the apex court. These parameters are as hereunder: 1, 2, 3, 4, 5, 6, 7. Take it. The contents of the FIR are reproduced hereunder for ready reference. Page 36, A to A. 36 to 30. This is a long FIR, huh? 36 to 40. Next, a perusal of the said FIR indicates that one Nilang Kashyap was introduced to the this company is Hudson.
Yes, ma'am. Page 37, at top, 37. It is start from 36. However, Mr. Kashyap stated that he was working with criminal investigation department.
Yes, I've got that. I'm just trying to see he was introduced to.
Yes, well, page 36, at bottom right. However, Mr. Kaishap said that he was working with Criminal Investigation Department of Assam Police. Therefore,
Was
wanted to
introduced to the informant around 5 years back, and it is alleged that he maintained constant touch with the informant and requested the informant to appoint him as their representative for the northeast states of India. However, since Mr. Kaishap stated that he was working with Criminal Investigation Department within bracket CID of Assam Police, therefore, he suggested that one of his close allies, i.e. Mrs. Dipshika Chaudhary, within bracket petitioner herein, be appointed as a consultant for managing all their operation in the northeast states, including that of Assam. Stop. It is the specific allegation that though orders were placed for transport, for different poultry commodities, the goods so transported from the informant's factory to Guwahati was found to be absent and the gudam of the informant. Accordingly, it was suspected that the petitioner, along with the other co-accused, have breached the trust of the informant and stolen the goods from the Sonapur Gudam. Stop. To constitute an offence under section 415 of IPC, the following ingredients are essential. Stop. I'll put it. In the present case, B to B, written arguments, respondent. Further, for the ingredients of section 405 of IPC are as hereunder. The basic requirement to bring home the acquisition under section 405 IPC are the requirement to prove conjointly entrustment with the property or domain over the property, and whether the accused was actuated with dishonest intention or not, misappropriated it or converted it to his own use to the detriment of the person who entrust. Thus, the entrustment of property is pivotal to constitute an offence under section 405 IPC. The word used within brackets in any manner entrusted with property extends to entrustment of all kinds, whether to clerk, servant, business partners, agent, attorney, or other persons, provided they are holding a position of trust. In the present case, C to C. No, that same written arguments. Where is that scope of work? Sarah, page?
Please, page 33, madam.
Page 33. Pertinent that the Appendix A of the Consultant Engagement Agreement dated 19/4/2021 stipulates the scope of work as hereunder. Page 33, D to D. Therefore, from the aforesaid consultant engagement, it is absolutely clear that the petitioner was overall in charge of ethical norms of all employees of the company for operations. It further appears that the petitioner is also required to assess the risk of prospective dealers and stakeholders. Stop. From the allegations made in the FIR and the materials collected by the investigating officer, it appears that the petitioner is connected with the offense alleged. since the investigation is at the initial stage, not to mention that the petitioner has not the petitioner has not cooperated with the investigation till date. Correct, that is there I saw. Comma, it is not a fit case to quash the FIR at this stage. Accordingly, the petition stands rejected, dismissed. I'll edit this
So there is an interim order, ma'am, that
interim order passed earlier, resultantly interim order passed earlier stands vacated. You will not get it immediately because there is some editing which has to be done. All right. Because this is a very exceptional case. There is, you cannot say that there is nothing.
No, in fact, there is a judgment that the Constitutional Court cannot pass FIR during investigation stage. So this is the initial investigation stage, and rule has been attributed.
Please give
to
it.
her.
Please give it to my court master. Yes.
I can praise it too.
May please, Your Lordship.
One second. Yes.
Lordship, I beg to mention item number 34, Lordship.
Item number
34, Lordship.
Yes.
Lordship, I highly apologize for the same because Lordship, I highly apologize for before Your Lordship. I unaware of the fact that the order has already been taken up in the morning, Lordship.
Yes. Order is already passed and signed.
Lordship.
Why the cause list doesn't say 10:30?
No, Lordship.
Doesn't say.
No.
Have a look. Yes. Any other matter?
Sorry, Lordship.
Lordship, I am for 22. Petitioner is coming, Lordship. For time being, Lordship. He's coming. Yes. And just cover.
Bakibur. So only
30.
item 30, none appears for the appellant when the matter is called. List after 2 weeks on a date to be fixed by the registry. This is what, 20? Yes.
He down. He was in leg, Lordship. He is down.
No, you are appearing for whom?
Petitioner.
Where is your file?
Lordship.
You are appearing in the court, you do not have a file, then you want the court to wait for someone who's not even here. What kind of a practice is this? You should be having a file.
Yes,
You're not even in a position to argue, not even a position to address the court. What is your name?
S.S. Bora. I am for, on behalf of P. Hazarika.
Your name?
S.S. Bora.
And who's appearing for the other side? You don't know.
No.
Mr. P.
Hazarika.
Mr. P. Hazarika, learned counsel for the appellant is present. None appears for the respondent when the matter is called. List this matter again on such and such date.
Obliged.
What I do is I take this, this I will allow one you.